One from the day's list, my lord. My lord, I have an order was passed in my favor by the learned tribunal. Now, my lord, on 10th of December 2025, I filed a contempt application in August 2025 before the learned tribunal. They did not comply with the order. My lord, in this fag end of the December 2025, they have preferred this writ petition. The state has preferred this writ petition. I am the respondent number one. There is a positive order in my favor. I cannot press the contempt there because there is no bench sitting there before the tribunal. And this matter is running in lordship's list since January, my lord. Is going on the list, my lord. It is item number 6 under compelling circumstances, my lord.
But you are respondent.
I am the respondent, my lord.
How can you mention the matter?
My lord, I am suffering because, my lord, because I cannot press
there is no order here coming in the way of contempt proceedings, you know.
My lord, your lordship knows, my lord, there is no bench
So
there.
therefore, it's not because of this writ petition.
My lord, if your lordship may kindly hear it out, my lord.
Not at the instance of the respondent. Cannot be.
My lord, they do not want to, my lord, press this writ petition. They have only filed it, kept it pending, my lord.
You would have had a cause of action had there been any order passed. Otherwise, you cannot.
My lord,
respondent cannot mention.
My lord, I am the successful, my lord, applicant.
Unless it is to your prejudice, the pendency you cannot mention. It is their right. They want to do it. They don't want to do it.
But I cannot, my lord, your lordship. I'm my lord, the remedy less.
You have understood what we are saying, and we have understood what you are saying.
But I am intended remedy less, my lord.
No, you are not. There is nothing to be remedied. You have an order in your favor.
Lord, they are not complying with the order, saying that we have a writ petition.
You have not come up, sir. You already said this. This is a repetition. We understand the entire situation, but there is no scope for you to mention as a respondent. In this, if there had been any order, we could have understood that there is something coming in the way. You may have had a cause of action, filing an IA or CAN, whatever you call it here. Otherwise, you cannot mention.
I'll come back to you, lordship. I have understood. Grateful.
Inclusions, please give your inclusions. What is that? Correction. Tomorrow, what is it? What is the correction? All right. All right.
May I have a lordship leave?
Tomorrow to be mentioned, Mela. Please mention the corrections that you want. Yes.
I have a lordship time leave to file this appeal without the certified copy. Your lordship, I have applied for the certified copy on.
What's the urgency, sir?
Your lordship, the order was passed on 3rd February. I am supposed to comply by today evening. So, your lordship, I just need to file
it.
I'm sorry.
Lordship, may I
You have given the usual undertaking. Yes.
Lordship, may I permitted to mention a matter for inclusion in the list?
All inclusions we have taken. You please give the inclusions.
Permitted to leave appeal which order has been passed on 29th January, and I have applied for the certified copy on 13th January 2026.
29 January order passed.
29th January.
How you applied on 13 January?
30.
30 January. All right, give it. You file it. Give the undertaking that you will give the certified copy.
Item number 1.
My lord.
Item 1, my lord, I am the petitioner, my lord.
Mr. Bandyopadhyay, Shrishana Bandyopadhyay is appearing in this matter, my lord. He could not come to court due to some personal difficulty. Can it be made not today, my lord?
Let's see. What's the issue?
But it's a very short matter, my lord. I am challenging an order passed by West Bengal Administrative Tribunal, my lord, where, my lord, my appeal has been being prolonged for end of time, my lord, for the reason that there is no availability of any bench. Neither, my lord, there is any single bench, nor, my lord, there is any division bench present at this room. When I am a 71-old man, my lord.
The issue, let us see.
Yes, my lord. When I am a 71-old man, my lord, I have been working as a Havildar before with the.
Where is your prayer in the OA?
Yes.
Which page?
But I'm good. But my OA starts from page number 27, and the relief sought for at page 36.
Challenging an order of dismissal of 2008 by filing OA in?
This 2025.
And therefore, it is very urgent that it has to be taken up.
No, but the urgency is this.
What is this?
No,
your OA is barred.
No, my lord, I'm indicating.
How it is not, tell us. Don't tell us, don't go into merits. Tell us how it is maintainable under in view of section 21. Tell us.
My lord, I have been acquitted recently. After my acquittal, my lord, from the criminal court, my lord, this OA has been brought into.
When you were acquitted, give
Yes,
the
my lord,
date.
my lord, that order, my lord, will
Where
find
is that in your OA? Come to your OA. Where have you said about acquittal?
Yes. Yes, my lord, kindly comes to page number 6, page number 32.
Yes.
Yes, my lord, clause G. The applicant was subsequently acquitted on merits by the said London Metropolitan Magistrate Vice Judgment dated 2024. Subsequently, my lord, I made a representation, my lord, which, and then, my lord, the appeal was dismissed.
So then after acquittal, what is to be done?
Well, after the acquittal, well, I have the charges from where this entire disciplinary proceeding stem from, that sole allegation, well, I have been acquitted from therefrom.
So
Nothing has been found. Now, well,
so-
I am entitled to, well, the back wages.
will show us any law on this point that the moment there is an acquittal, you are entitled to all back wages in the departmental proceeding. Show us one judgment. Cannot be, sir. Simply cannot be. You know that.
Well, I'm not.
Just show us.
No, the
Everything is a very simple matter.
Yes,
You were convicted in 2008, acquitted in, held guilty in proceeding in 2008.
Right.
It is your claim for the same allegation on the same evidence you were acquitted in 24. Therefore, all back wages should be paid to you. Please show us any law on this point. One judgment which is binding on us. The law is quite settled, sir. We all know. You have to approach the authorities, they have to apply their mind, whether it is the same evidence, whether it is the same set of charges, what is the entitlement of the petitioner. Only thereafter you can approach the court.
My lord, may I draw my lord's
Therefore-
attention to page number 102?
Yes.
My lord, this is, my lord, the appellate order, my lord, kindly sees. The appeal was in 21, 2020.
How does it matter?
No, my lord,
How does it matter?
lord,
And
at
how
least-
you can file an appeal after decades?
No, my lord, I'll
You're doing everything wrong and you're creating a mess for yourself.
No, my lord, the circumstances
The
are.
only thing which is required to be done is upon acquittal, you're required to inform the
I
authorities
have done that.
whether you can get any benefit of that or not. If they pass an order or if they refuse to pass an order, then you can approach. This is not, there's nothing in this appeal or this OA.
No, my lord, may I indicate? Well, kindly, may I indicate? My lord, it is not only that, but in the OA, if my lord may kindly sees, in the appellate order that we have challenged, that is of 23, 2025. The appellate order that we have challenged, that is for 23, 2025.
Where is that prayer challenging that order?
My lord, kindly sees page number 36, bottom 7A. An order, an appellate order dated 23, 2025, and the final order of dismissal 24/7,
Page?
page 36, bottom. My lord. First prayer, my lord, relief sought.
So what is wrong in that order? Let us see.
Yes, my lord, that order, my lord, is at page 102.
Yes.
The 103 bottom is the operating portion. My lord, may I place it?
Yes.
The appellant has filed the instant appeal on the ground that he has been acquitted by the learned court from the criminal case which was also registered against him over the issue. But it is to be noted that registration of the state criminal case and its related investigation or trial were not the subject matter of the charge framed against him in the instant proceeding. Moreover, it is pertinent to mention that the purpose of the two proceedings are different. The object of departmental proceeding is to ascertain whether the officer concerned is a person to be retained in service or not, or to be dealt with by imposing a suitable penalty. On the other hand, the object of criminal prosecution is to find out whether the ingredients of the offense as defined in the penal statute have been made out. The standard of proof required in a departmental proceeding, my lord, kindly marks, is also much lighter than that in a criminal proceeding. While the criminal court insists of proof beyond all reasonable doubt, in departmental action, proof of preponderance of probability is sufficient. Evidence which is not sufficient for a conviction by the court of law may be sufficient for establishing a charge in a departmental proceeding. Further, in terms of Regulation 4, Chapter 9 of Police Regulation, in order of discharge or acquittal of a police officer by a court is not a bar to the award of departmental punishment to that officer in respect of the same cause or matter.
This is not something which can be raised in
Now, kindly turns to page 105, where the administrator of tribunal has admitted this by appeal. After admission, my lord, this has been
pursue it there.
But I'm for that only, my lord. Kindly expedite it. I'm a 71-old man, my lord.
You have see how an appeal is maintainable on this fact. Appeal is challenging the order. Appeal cannot be filed based on a subsequent event. For that, you have to bring it to the authorities' order. The disciplinary authorities notice whether he will take any action, any cognizance of this or not. How it can be a ground for filing an appeal? So many decades later, you were held guilty in the proceeding in 2008.
The appeal that I filed, that was within time, and the appeal has got adjudicated recently.
Appeal is within time. What is the
Within
date?
time.
What is the date of filing? Give us.
The appeal,
What is the time for filing an appeal under the rule?
The order, my lord, that has been passed.
What is the time? When you say it is in time, that means you know what is the time limit. So what is the time limit?
30 days.
So it was filed within 30 days of the order of in the disciplinary proceeding.
Well, on that, my lord, I don't have the copy of the appeal, my lord, with me.
Please come to page 1027 line. Don't make false submissions. That's
But
not appreciated.
I apologize, my lord, for that.
Please don't make false submissions. You don't gain anything by making a false submission.
No, I apologize. I missed out, my lord. I apologize.
You bring it to the notice of the disciplinary authority. Take him now. How he can take a decision?
But I am just praying for innocuous innocuous relief, my lord. But kindly, my lord, if this be expedited, my lord, I may lose, my lord, I may win, my lord. Kindly expedite this.
Cannot be. When we know that there is no member, how can we direct for expediting? You file an opposition. We'll see. The petitioner approached
To say appear on behalf of the petitioner, my lord, matter. My lord, this matter, the petitioner who is before your lordships is presently working as the delegated contractual worker under the Murshidabad Health Center. Now, my lord, he is aggrieved by the part that he was not given the remuneration, the benefits of the remunerations which has been floated by the government of West Bengal towards such delegated workers. Now, my lord, he had preferred an original application before the learned tribunal, which is pending. Now, my lord, during the pendency of the original application, while the matter has been fixed for hearing, my lord, he is agreed by the order which is reflecting at page 98. Suddenly, my lord, the respondent authorities have stopped my salaries and I have been put on bench. I am not being given any work. Well, this is the short sum and substances of my submission, my lord. That while the matter is pending there, I had prayed already that I may be given the benefits of the beneficial legislations of the government of West Bengal. But suddenly, my lord, I have been hit from the bolt from the blue at page 98. Now, my lord, the two number of employees of district SBCC cell, Murshidabad, namely Shankar Pal and Rupesh Kumar Das.
When this was communicated to you?
Well, lord, this was communicated. Cannot Kobe. Kobe. So, phone dated. Well, that I cannot.
In a decision in a file can be challenged. Tell us the law.
My lord, may I say, my lord, even if, my lord, the effect is given by pursuant of this.
We don't know.
Kindly sees,
We don't know.
no, lordship, kindly sees the contents of the note sheets. What I've
We will not. We are not obliged to see the contents of a note sheet which has not been communicated to you. There is no prejudice by an intra-departmental communication. This law is very well settled. Therefore, we ask you when it was communicated to you. Unless it is communicated, where is the cause of action? They are moving files. We don't know ultimately what they will do. They will stop. They will not stop. What sense will
the
prevail?
cause of action has already arisen by which my salary has been stopped.
Show us. Where is that averment that it has been stopped? In your MA, where have you stated that they have stopped the salary? In para 15, you say he will suffer irreparable loss.
As per paragraph 11, I have stated.
Yes.
Page 90, the petitioner submits the respondent authorities has acted illegally and gross arbitrariness by stopping the petitioner's work together with salaries of the petitioner, whereby the question of his life and livelihood depend. Well, I have stated here, my lord.
No, sir, you read it with paragraph 15.
My lord.
At the bottom.
That unless the petitioner states that unless the impugned decision is cancelled and the authorities are directed not to give any effect or further effect to the decision.
He will suffer.
Yes.
There is no material to show that salary has been stopped. This is not unreliable.
Well, let the respondent authorities.
No, why let the.
That my salary has been stopped, my lord.
We don't think so. There is no specific averment.
This is my lord, paragraph 12 also. I have stated paragraph 12, 11, 12. The petitioner submits that the respondents concerned acted in gross high-handedness by stopping their service and salaries on frivolous ground, and that too during pendency of the said original application, and the said decision is liable to be cancelled and or set aside. And my lord, in paragraph 10, I have specifically stated that the reasons for non-stopping of my salary on the basis of the note sheet, because the reasons have been given. The petitioner states that when such is the state of affairs, a note sheet signed by the concerned authority on 26/12/2025 has been served upon the petitioner by an employee of Murshidabad Collectorate District Rashtrasati Cell, wherein it stated that the petitioner and another Shankar Pal cannot be given their respective salaries due to non-availabilities of fund in salary cell, and their services may be stopped until further order. Now, paragraph 10, 11, 12, I have stated therein.
What have you filed the MA for amendment?
No, my lord, it was to bring this note sheet on record and for getting the benefits, setting aside or washing of the note sheet.
How it can be? You will have to include this as a prayer in the OA. How it can be set aside in an MA?
No, my lord, that has been the prayer.
Please come to your prayer.
Yes, my lord. Page 91 is the prayer, my lord. Under the circumstances, the petitioner most humbly praised. Honorable Tribunal may be pleased to direct.
You have to include it as a prayer in the OA. Please try to
Yes,
understand
my
what
lord.
we are
The
saying.
amendment of
This cannot be done. How it can be set aside in an MA? How it can be? This has to be a substantial relief.
Yes, my lord.
Then why you have filed such an MA in which nothing can be done? You tell us what can be done in such MA. Unless you include it as a main relief and then you file a MA for interim relief, if at all it is available, we don't know. Once only after they say whether they have taken any decision or not. Secondly, your claim how enforceable it is, that also we have seen. You are not you are claiming benefit of which memorandum?
Yes. Well, all these sets of memorandum already started from
You are
2016.
today claiming which memorandum benefit?
Yes.
You have got 21,000 rupees per month. So therefore now which memorandum you are claiming?
Yes. 99.
Come to page 67. That is the memorandum you are claiming benefit of.
Yes.
How you can get it? How you are covered by this?
Entered more than 10 years also. আমার কতদিনের সার্ভিস হয়েছে গ্রুপ সি ওই জয়েন করে রিটার্ন করে But I have served 15 years to less than 20 years. That is the slab, my lord, because I have joined there.
You have joined on 26/7/2008.
Yes.
So you have whatever that is, but again we are asking you how this memorandum will apply to you.
Because, my lord, I have the only criteria is, my lord, the length of
That's all.
service is there.
After reading, you are saying that.
My lord,
After reading this memorandum, you are making such submission, or only upon instruction you are making such submission?
yes. Well, I'm a group C category there.
Again, you are missing the point. Problem is you are not reading. If you read, then you will not respond like this. This was for utilizing service of excess employees from board corporations, those who have been redeployed. You are not a redeployed person.
No, my lord, but my name has been recommended on the basis of such.
If you are claiming benefit of this memorandum, you have to be a redeployed employee. The question of improving the conditions of service of such casual, it says such is above, it is stated that they are redeployed because they were rendered surplus by winding up of certain boards and corporations. You are not covered by this memorandum. You may have served 30 years, but you will not become redeployed.
Lord, may I say, my lord, one thing, my lord?
Yes, you may say two things.
My lord,
You may say two things.
my lord, all these memorandums, my lord,
All these we are not concerned.
I take
Today you are claiming benefit of 15/7/19. How it applies, we are asking you in the OA where you have said that you are redeployed. That's not your case. So what remains in the OA? Forget about MA. Come to your OA where you have said you are redeployed. That this applies to you because you were rendered surplus by winding up of any board corporation and that you are redeployed. Where have you said how it applies to you?
But these are the continuation memos.
Sir, we are asking you, there is nothing in continuation. Today you are seeking benefit of 15,719, nothing else. Everything else you have got, whatever was for everyone, you have got it. You have come up to 21,000. That is your admitted case in the OA. Now, how this applies to you? See, he has already got 21,000. How he can get it? OA is pending for no purpose. We cannot rewrite the memorandum. The memorandum is applicable only for those for which the memorandum is issued. It is not your case that you are.
So kindly see page 74. My name has already been recommended by.
Very well, you be happy with the recommendation. You be happy with the recommendation.
Kindly see my lord, page
Yes.
74, my lord.
That will change the memorandum. How that will change the memorandum?
But this is the understanding of the authorities. I am there. Therefore, my lord, I have claimed.
So you rely on their sense. It may be more beneficial for you because we will go by the memorandum. We will not allow them to extend this benefit to anyone other than this for whom it is intended. How it can be? It's not an arbitrary, it does not give an arbitrary discretion in any authority. The object and purport of the memorandum is clearly stated in the first paragraph. Companies, corporations, undertakings, statutory bodies wholly or partly owned or controlled by the government. If you are rendered excess, surplus, then you will, if you have been redeployed, this is to give some security of tenure to you and to allow the government to utilize your service properly.
No, Lordship, there is also another term written there.
Yes, let us see.
Government of West Bengal or by anybody.
Yes.
I come under the purview of or by anybody.
You do not, you have
If-
not come from anywhere. You have not come from anywhere. You have directly been appointed. You have not come from anybody. In 2010, the DM light your face, you were taken on.
No, my lord, there was a.
Show from the OA, from where you have come, which body you have come.
No, Lordship, that is the part is there.
From which body you have come, show.
No, Lordship, here that will not be coming up because or by anybody. Manoj, here or by anybody would my lord.
Sorry, then we will just now we will deal with it. Don't worry. If
Or
that is your submission, we will deal with
by anybody would mean, my lord, not the earlier part of the
All right.
deployed.
That's all. There is nothing.
It's by now, Lordship, kindly says or by those entities, organizations to other entities, organization, and in government offices.
Yes.
Under any project scheme.
You have
wherever
not,
necessary.
you have not, see, you are reading something which there is no foundation in the facts. You have not come from anywhere. The district magistrate liked you and you came in. It is just like that. It is as simple as that.
So, Lordship, it also states that and in government offices under any project scheme.
Sir, from it may say anything from where you have come. That is the point. Don't read the memorandum. There has to be a fact on which the memorandum will apply. That fact is not there.
I tell you, Lordship.
26/7/2008, you were liked by someone, you came in as a contractual employee. Nothing, no sense of procedure, no sense of assessment, nothing. Applicant district magistrate administration. Which district administration administered advertisement when? Other day. Applicant having the profit, what will this? Nothing. Give us place. In which list? Then comes election A. The election. Why this amendment has been made? No. There is nothing. You see an exception. Engagement letter to the post office system. There is nothing that is based at serial. When the advertisement of show nothing. This was for 6 months contractual. These are stuck in some months. Series of implementation of this thing. When the second position, then first candidate did not join. To make out a story in your application that there was requirement, there was an advertisement, you participated, you were a second panel candidate, and then you were engaged. When the advertisement, what was the requisite qualification, where is the empanelment? Nothing. Nothing in support of such averments.
If your lordship's desires.
And you are bound by page 40. Just see.
Yes, but apart from that, my lord.
Under UNICEF funds, the district magistrate takes you for implementing certain schemes for 6
Yes.
months. You have been fortunate enough to continue till now,
Yes, now lordships may
excluding all others who were eligible.
My lord, may I say?
And
my
now
lord?
you want more,
My lord,
as
may I
if
say-
you are the most fortunate person
may I
in
say,
the
my lord,
district.
one thing? Lordship may kindly seize my reliefs in the original application once again, my lord.
You may read it once again.
My lord, page 36.
Yes.
I have relied upon not only the 15/7/2019 memorandum, but also the memorandum of 1st March 2024 at page 70.
Yes.
It covers my case.
Very well.
Kindly seize, my lord. The question here, my lord, there is no question.
How do you substantiate your averments made in? See, we have to be satisfied of the bona fides. How do you substantiate your averments from para 6.2 to para 6.4? If not, why you are being continued for 15 years? That is your averment. You are obliged to make out that case with reference to any document. Any document which may show that there was an advertisement, there was a requisite qualification, there was assessment of merit, you were placed second in the panel. Any sheet of paper to show any of these things. You read 6.2 to 6.4 and then you come to page 40.
Yes.
Totally incoherent. There is no coherence.
Lord, we will show that to your lordships, my lord. She is having those documents.
Then place it. For filing a supplementary affidavit, we adjourn the matter. 2 weeks, full stop. The learned advocate for the writ petitioner submits.
This matter,
Now what is there in this one? Again MA.
well, this is the almost similar. The only difference is, my lord, in the earlier case, my lord, he was engaged therein, and here the engagement on the basis of no sheet. Page. Lord, page 41 is the initial letter by which he was allowed to join, and my lord, after that he has been continuing there, and the extension has been done from time to time. And my lord, his salary at present is 15,300. Now, this is the only difference.
Engagement was on a stipend.
My lord, he was initially, my lord, joined as trainee.
What is happening? How are these people taken into service like this by the district administration? What lordship? Who is to this? Who will be responsible for these engagements? Which officers? There is absolute discretion in these district authorities.
You have to take instruction.
Thousands of people are waiting unemployed, and just like this, come and then you start working. What is the process leading to this issuance of page 41? You can say anything, you can say HIV, you can say UNICEF, you can say anything, and then continue and now give them 21,000 rupees a month. They are the most fortunate persons in the district. Everybody is waiting for a job, and just because one day the district magistrate likes him, he starts working and he starts climbing the ladder in terms of salary, and now he wants more. Kind of appointments, these are how it is being done.
You have to take instruction.
Please tell us on the perusal of the original application. And
Lordship, Mr. Arjun Rai Mukherjee is appearing on behalf of the state. Your Lordship, he's on his legs. Not today.
Notice that. Previous notice, my lord. কবে করবে বলো?
If he doesn't want to appear, let him not appear. You proceed. You have intimated him. These old matters we are not going to adjourn. Yes.
First of all, my lord, the main writ petition has been come, my lord, against the order passed by the learned tribunal, state tribunal, my lord. And thereafter, my lord, it was given for default. For why we have given section 4 application, section convention delay, there was substitution and contempt. There were first, my lord,
Restoration, substitution, and
restoration, substitution, and contempt. Pending contempt. All the contempt application also there, my lord.
contempt.
Contempt is there. My lord, here, my lord, first of all, I want to praise, my lord, the 3, the convention of delay. Restoration, my lord. And 5 and 4, my lord, section 4 delay, section 4, can 4. Therefore, my lord, your lordship may take first, my lord, section 4, can 4. The Limitation Act.
Very good. Let him come. First, we send an invitation and then he needs an adjournment. No, sir. Why you are not here on last day? These old matters will keep sending information to you. Why?
You have not served all applications.
We don't know. It is all served. Here we are showing it is showing all served. We will not allow you to take such plea. Don't raise such plea only for the sake of adjournment.
Can 3 for restoration, my lord. Did not, my lord, where the children, the deceased government employee, and against the judgment and order of the tribunal, we have come here. But
Where is the tribunal's order?
pardon?
Where
Yes,
is the
tribunal order. And here is the tribunal order, page 72 of the WPA, WPSC. Kindly, have you got it, my lord?
What is the date of the order?
Date of the order was 20. That is mistake, my lord. It has been typed 28 2003, but wrongly typed as a 3, my lord. Kindly, I correct it, my lord. Wrongly dated as a 3, but type it. But actually is 28 2003. Judgment delivered in open court.
20th August 2003.
Yes, my lord.
Yes. That is the wrong date.
Wrong. That is wrong type. 8 is that 3. It has been written 3 in place of 8, my lord. We have also overlooked it.
So it is 28 2008.
3. That is page 72 of the original report.
2003. According to you, what is the date of the order?
Huh? Yes. My lord, the judgment delivered in open court is present on both the parties. separate, the case is dismissed by judgment passed in separate sheets kept to the record.
According to you, what is the date of the order?
Order is the original order was 28th August 2003, but it has wrongly typed, my lord. I have overlooked. The 23 it has been written at the first paragraph. Section of can 3.
No, come to page 74. Come to page 74. Date is correct.
72 of the original writ petition, man.
Page 74. See page 74. Date is correct. 28, 2003.
Yes, that is. I'm sorry, my lord.
That is a correct date.
Yes, that is the order and
Yes.
enter judgment, my
So
lord.
don't worry. That typographical error is of no. What is the order? Let us see.
Order is the, my lord. Yes. WPST 53 of 2004. WPST 2004. Order dated 8/6/2004. By this honorable court, my lord. Of the honorable court. Page 24. Page 24. Application opposition. Having on a file. Yes, contempt petition. Yes. Contempt petition मतलब CPN 17 में 2 आते. Affidavit in opposition be filed within 4 weeks from date and reply, if any, be filed within 2 weeks thereafter. Let the matter appear thereafter. With regard to the subsistence allowance, the complaint of the petitioner is that the entire subsistence allowance has not been paid to the petitioner, which he has entitled before superannuation. The learned advocate for the respondents states that no such amount is lying due. In the above view of the circumstances, respondent number 2 is directed to decide as to whether the petitioner is entitled to any amount or arrear of subsistence allowance. If any such amount is found due, the same may be paid within a period of 3 months. If no such amount is found due, the same may be communicated to the petitioner. With regard to the retirement benefits, the respondents are directed to pay any amount which may be admitted by the respondents as payable to the petitioner in accordance with the law, and such payment is to be paid within 3 months from date. And that is the order which has not been obeyed by my learned prince client, and that's why contempt application, my lord. That is number CPA number 76 of 2005. 373. 376, sorry, 376 of 2005. 88. Service. Receive the contempt application copy. আগে থেকে দেওয়া ছিল তো পুরাতন বহু পুরাতন ম্যাটার তাহলে কি করবে তাহলে
2004 there was old panel. In 2000 we came to 2011. How should I get the
You ask your government, why are you asking him? You ask your government why they are doing this, changing you every 10 years without giving you the brief. Why are you asking him? No, you are asking me, how are we going to have the copy? Don't ask him. That's your headache, your client's headache, not his headache. By making loud submission, it will not work. Making relevant submission will work. No, you are not. You are asking him how we are to have it served in 2004.
Said matter has been displayed for আবার তো একটা দেবো এখন আচ্ছা দেবো এখন দেবো এখন no problem.
Request him, don't shout at him or anyone. You give him. On prayer of the learned State Council, we are adjourning the matter for a week. We are not recording anything. Request him to give you a copy, or next week we will not adjourn it on this ground. You take a copy from him, you get it Xerox, whatever you want to do.
কবে চাই বলো এখন
16
তোমার নামটা নামটা
Madam, 16th February te আছে. Item number 5.
No, don't apologize. Once case is over, everything is over.
আমি দেবো কি চাই বলো সব দিয়ে দেবো
My lord, I am appearing for the applicant.
Such a senior person, you should not be speaking to him like this. That is all we wanted to say.
This pertains to correction, my lord. Second number 5. I have served upon all the parties, my lord.
আরেকটা কপি
What is the issue?
This is, so far I understand is concerned, my lord, this is a correction of the order passed by, my lord, Justice Tandon sitting with your lordship, my lord.
Yes.
12 December 2023.
Yes, my lord.
What is the correction?
Correction is, my lord,
The correction is, my lord,
That
in the second
correction
page.
he seeks is in dispute.
No, that was amicably settled down, my lord, in between the parties. The only correction.
Therefore,
is required, my
any
lord,
one
is
of
in
you
page
can tell
number
us.
14 of the CAN 2 application, where, my lord, in paragraph number, in second paragraph, 4th line, that it has become, my lord, plaintiff appellant. It is supposed to be plaintiff respondent, my lord, because which is correctly written
Page
in
14.
Page 14 of the CAN 2.
14 of the order, or if your
Page
lordship,
2. Page 2 of the order.
Page 2 of the order, which part?
Page 2 of the order, if your lordship kindly see, but the second paragraph,
Second.
the line starts with in course of hearing of the instant appeal, the proposal and the counter proposal were made by the plaintiff respondent as well as the said developer, and it was agreed by the plaintiff appellant.
Oh,
that it should be
respondent.
Plaintiff respondent.
Respondent. That's the only place.
That's only correction.
So all parties are here.
And I am the appellant before your lordship. He is the contesting respondent. He contested. If you lordship see the earlier page, so the order starts with, but Mr. Prantik, I am for the appellant.
Oh.
My name is, and the
Builder was not there anyway. The application is filed for not for pointing out a typographical error having crept into the order of the court dated 12/12/23. Stop. The order in paragraph 2 of page 2 wrongly records plaintiff stroke appellant in the 4th line, comma, instead of plaintiff stroke respondent, full stop.
respondent number 1, it will be.
Plaintiff stroke respondent. It's everywhere it is respondent.
What happened, my lord, plaintiff was a single person.
Yes,
He was described as respondent number 1 here.
yes. Plaintiff stroke respond number, but then everywhere it says respondent, then all those places will have to be
Yeah,
corrected.
other places it is referred as plaintiff respondent.
Therefore, let it be as it is. There should plaintiff respondent, full stop. The defect, the error, typographical error is obvious from perusal of the order and records and is not in dispute between, and there is no dispute in this regard between the appearing parties, full stop. So we therefore direct that that plaintiff stroke appellant, second paragraph of page 2 of order dated 12/12/23 be read as plaintiff stroke respondent. The order stands modified accordingly. The CAN application is disposed of. Is allowed. CAN application is allowed.
For this correction, we got a chance to appear.
Huh?
For this correction, I got a chance to appear again.
No, no.
Observe.
Item number 6. The respondents, my lord. On the last occasion, my lord was pleased to hear out the appellants, my lord. This is a review application, my lord. The appellants have admitted that.
Yes, which decision you want to cite?
Yes, my lord. But they have cited a judgment on the point that subsequent to the passing of the judgment sought to be reviewed, the Honorable Supreme Court in an identical matter has held otherwise. My lord, I've gone through that judgment also. Firstly, my lord, that judgment doesn't say so. It's in line with my lord's judgment. And my lord, before that, my lord, I wanted to show that my lord, Order 47 Rule 1 explanation in the my lord, Bear Act itself. My lord, it says that review is not maintainable on such ground. May I just read it?
Yeah, there is a very recent judgment on this point also.
Yes, I have come up with that, my lord. Even the Bear Act, my lord, the Act says so. May I just only read it once, my lord?
Yes.
Explanation. The fact that the decision on a question of law on which the judgment of the court is based has been reversed or modified by the subsequent decision of a superior court in any other case shall not be ground for the review of such judgment. My lord,
Very recent judgment.
yes, my lord. This is Canara Bank versus M. Michael Raj. Manu slash SCOR Manu SCOR slash 69810 slash 2025. This is not available in SCC as such.
There is even a later judgment, very recent. I think within a month or so.
Found this, my lord.
Anyway, the law is very well settled there.
I'll hand over mic. Then this, my lord, says paragraph, my lord, 4 onwards, my lord. As 4 are the facts, my lord. Paragraph 6, my lord. The court has pointed out, my lord, on the earlier 2 judgments. I have a copy of that also, my lord. 5, my lord, kindly see the petitioner having gone into the deep sleep for 8 long hours suddenly woke up from his slumber to file a review petition. Obviously, as could be seen from recitals or the averments extracted in the impugned order, whereby similar employee had been extended the benefit, which seems to have triggered the petitioner to file a review petition, or in other words, the subsequent law laid down in case of another employee enlightened the petitioner to file a review petition. In fact, the review petition itself is not maintainable in as much as explanation to Order 47 Rule 1. CPC is a complete answer to the same. It clearly prohibits filing of review petition due to subsequent judgment, and the expression used thereunder is a complete answer to this proposition, which reads thus. And even, my lord, that judgment also, my lord, that judgment has held, my lord, that an appeal would not lie even at the behest of a third party against a Lok Adalat award. And in the judgment sought to be reviewed, my lords have held that a suit for partition can be maintained by a stranger, but and a declaration can be sought for that such decree is not binding upon him. I have not, my lord, challenged the, my lord, validity of that decree before the court below. But I have only said that that's not binding upon me, and it's a suit for partition. My lords have made that distinction in the judgment, that a suit for partition, unless, my lord, being decided, my lord, in my presence, my lord, I can always maintain a suit, and that's a recurring cause of action. Now, apart from that, 3 judgments which they have cited, my lord, those 3 judgments were, my lord, distinguishable on the fact in all those 3 judgments there was an admitted mistake on the part of the court, and on such ground the court, my lord, used that, my lord, term given in the Order 47 Rule 1, any other sufficient reasons. Now, I say, my lord, this any other sufficient reasons means a reason sufficient on grounds at least analogous to those specified in the rule. That is either error apparent on the face of the record or any subsequent. And my lord, in their review also, my lord, their only ground is that, my lord, that my lords, after deciding that the suit was maintainable, my lords have not heard them. In the judgment, my lords have clearly stated that they have not made any submissions on merits on facts. They have only made submissions on law. And that's not a demurrer point. They said that generally what happens after my lords decide demurrer, my lords enter into merits. It's not so. An order of injunction was passed in my suit in the court below. They have challenged that. They have only challenged the maintainability of my suit in the court below on 3 grounds: res judicata, section 21 of the Lok Adalat Services Act, and third, my lord, that I do not have locus standi. And 3 of them, my lords, have answered. Noticing that there were no other submissions made on merits. May I just show that portion? Yes, page 18. Not from bottom, my lord, 7-8 lines above, my lord. Since the arguments were not advanced on the merit of the appeal, there were no submissions made on the merit. And this matter was heard, my lord, on several occasions. My lords have given full opportunity to the parties to place their case. And my lord, in any way, my lord, this cannot be a ground for review.
No, but it's also not their ground that this fact which has been recorded is an error of record.
No, not but they
Not
admit
their
so.
case.
They admit so.
If that had been their case, then there may be an occasion. Otherwise, what they are saying substantially is that the order is not correct. That's all. Anything you want to say?
But the point argued by my current should have not given me the copy of the judgment.
For this point, you need copy of the judgment. You must have read this
in either AIR
provision. You must have read at least 100 times this explanation.
No, that is there.
Then this is all the judgment says, nothing else.
I tell you, Lordship, only one point.
Yes.
I can cite the judgment. The Supreme Court has also held, and our division bench has also held. If a judgment delivered by the Supreme Court, it is binding upon all the courts. If
This has to be laid down. This is constitutionally it is established.
and if it is found in the review application that that binding precedent has not been properly followed.
No, that is a different thing. That's a different.
Well, this is a case. This is in our
That is a
case.
different thing. That's, see, your submission has to be as per the facts of your case.
Yes,
Not just stating the law generally.
Well, I started to place my facts before your lordship.
Yes.
What was our case? What was the suit for partition and
Not those facts. Whether that judgment was there on that day. That is the only fact you have to.
The subsequent judgment, or what I am
Therefore,
saying, that was not there.
Then
The subsequent judgment, what says, my lord, the judgment
Then
which your
your-
lordship relied on,
Yes.
which your lordship relied on, but that has been just clarified in the subsequent judgment.
maybe. So it is a subsequent development. It was not in existence.
My lord,
That is an admitted position. There's no
that
dispute.
was my subject to correction, my lord. That was in existence. Only thing, my lord. my
No,
lord had-
sir. It is much after. Don't say it was in
My
existence.
Jalandhar, state of Punjab of the Jalandhar Singh court, my lord, has relied and delivered the judgment. In that judgment, it has been clearly stated that if it is settled by the Lok Adalat, that can only
Just
be
give us the dates on these relevant dates you give us on a piece of paper. The relevant dates of the judgment and all this.
then I shall prepare it and hand over to your lordship.
Yes, give it to us. That the
Point, my lord. May I only, my lord? Wait, my lord. Sanjay Kumar Agarwal.
Or list
Kumar,
of
this-
dates for orders, give a date after
CAB.
4 weeks. List on
CAB.
No, we'll pass the order on 10th March.
Grateful to you for giving me one opportunity of hearing.
We are hearing you every day.
10th March for order.
Sir, will no matter, my lord.
Now,
We are
no,
here.
no. We know that you are more seasoned than to be worried by such
For
things.
order. Item number 7.
Like that day, I have come to your lordship and submitted two judgments regarding, my lord, the Supreme Court judgment regarding the mental entry of the review application. That day, your lordship asked me the question, and I have submitted two judgments. One judgment, my lord, Justice Hegde and Justice Sinha, where they have come to a conclusion that initially, if any phase of record is wrong, then the review application is maintained. And another judgment, very old judgment, 1955 judgment, that also same principle.
No, we don't remember. You are relying on our memory.
No, my lord, your lordship have enough memory. Yes, lord. My lord, I have heard from my Justice Tandon. Your lordship have enough experience, and my lord, that judgment, my lord, AIR 1955, Calcutta 92. मतलब Parmacel Well Storage Distribution Company India versus the labor appellate burial respondent.
First, tell us what is, we don't remember exactly. What is the review that you are saying?
Well, review is question, my lord. At the stage of Order 41 Rule 11, your lordship sitting with my Justice Tandon dismissed the appeal on the ground that no, the recovery possession and the relief is made by the plaintiff is correct and maintainable. But very vital point, whether the suit is maintainable or not. Because, my lord, I am not taking enormous time, very short time, my lord. Regarding the school is concerned, it's a government school. But the government school run by the government finance and also the development by the government. But here, only they have made party the school authority and also the head teacher. Suppose today the degree obtained, but it is not an effective degree because
You are the defendant.
I am the defendant school authority. Teacher represent a head teacher is represented by the school. Well, that day I have submitted before your lordship that today I got a degree against the head teacher. Is it executable? My answer is no, because head teacher is the employee. Because the school is the custodian of the collector or finance department of education department. If the education department is not party to the suit, how is the suit is maintainable? That is why the trial court dismissed the suit a defect of party. But the appeal court as well as Honorable High Court, my lord, somehow, my lord, misunderstanding or my lord, whatever may be, my lord, dismiss my appeal. My contention is that, my lord, that day, my lord, I have submitted two judgments, AIR 55, Calcutta 92, my lord, regarding the Burma sale. Here, my lord, where judgment passed, which cannot be executable, that is not good judgment. Because the proper party is necessary. Because proper party, if not, then degree cannot be executable. Because today, the trial court, by way of execution, direct the self-belief, court self-belief. Yes, you go and keep the vacant position and demolish the structure. The school authority cannot. Because school authority, the head teacher cannot give the vacant position. He is the management and he is the head teacher of the administration of the school. But while the school established in the year 1910, near about 200 years, 100 years ago, the school was established. where the father of the plaintiff was studying, and his lifetime he was also filed a suit. That suit was dismissed for default, but without leave, the daughter and son filed the instant suit. However, we have taken the point the suit is defective party, but that point has not considered both the first appellate court and also the Honorable High Court. That is why review. But one thing, my lord, one judgment, my lord, reported in 2000 AIR 2000 Supreme Court 592. Here one point taken and come to a conclusion that under Order 47 Rule 1 Code of Civil Procedure, filing an application for review, then application for review would be maintainable not only on the discovery of new and important piece of evidence when there exists or error apparent in the face of record. Here, my point is there is a existence because we have taken the point that the suit is defect of party. If the suit is defect, so that cannot be executable, that cannot be degree. That is why trial court dismissed the suit. And my lord, next point is my lord Justice Bhaskar Bhattacharya and my lord Justice Pavendra Narayan Sinha. One judgment, my lord, reported in 2006 to CHN, page 680. Here also come to a conclusion that according to the Apex Court judgment, 1995, 1 SCC, page 58, the face of record, if mistake, that should be corrected by way of review. My point is, another point, my lord, one unreported judgment I am citing, very recent judgment. Morser, Than of Yadaro Mahajan, Binayak Venkatesh, Sitaram Bedi. Here, here, the court come to a conclusion where the trial court framed the issue as to whether the suit is bad in law for non-resident of necessary parties, that suit cannot be maintainable. For that reason, my lord, they have come to a conclusion.
So actually you are re-arguing the case.
That day I have not, that point I have forgiven. That point I will
Actually you are re-arguing the case.
You are my renew. That's now your lordship asked me.
You are re-arguing the case. You want to re-argue the entire matter.
No, I am coming that.
No, that is precisely what you are doing. For 10 minutes you are arguing the case as if it was never argued earlier.
I'm taking my lord 5
You are relying on judgment regarding
5 minutes time. 5 minutes.
Yes.
My lord, it is, my lord, from the above, it is now clear that two tests are to be satisfied for determining the question, who is the necessary party? Here, the Supreme
Why, sir? Why in review? You are going on the merits as if you are re-arguing the matter.
Court, I am going to the fact of the case.
You are going to the
that
fact
point.
of the case.
Only that for the issue.
Any point, why it should be considered in review, that you show us on that judgment.
Yes.
Don't show us a defect of party, whether it is a suit is to be maintainable or not. Show us that in a review all these things can be argued.
Well, that is why I have given
That we are unable to.
I have given the
Yes.
judgment, 2005 judgment.
Yes. Which paragraph? 88 and 80 and 90.
88, 90.
So what is the mistake in the anyway? All right.
Mistake regarding the, my lord, defect of party. Very well. I am giving the judgment as lordship passed the order, but I am giving the written argument also. That your lordship may consider it or not.
Don't give written argument, give the judgment. Why do you want to give written argument?
No, it's my argument. Your lordship regularly says.
You are arguing for 15 minutes. Why written argument is required? We will take note of everything. You give us.
notes. It's a notes of argument. Your Lordship, kindly consider.
All right, give it.
I consider.
Are copy.
My Lord, some judgment I am referring. Then, my Lord, I will conclude my argument.
You have given her the judgment.
Regarding the necessary party.
No, this judgment that you are relying on today.
My Lord, 2005-6 STC.
Sir, just now you were giving reference to some judgment today for the first time. Which judgment is that?
I am giving the judgment. Now, my Lord, the unreported judgment, Supreme Court, very recent judgment.
You have got a copy of that.
Yes, this. And my Lord, another judgment I am giving. The 2005 Supreme Court case 733. Kosturi Bhatsa, Yamatu and others regarding the necessity of the necessary parties. Volume 6.
This judgment you are relying on which paragraph?
Which paragraph? 19, 18.
18, 19.
Yes, my Lord.
And that one? That one?
It is, my Lord, year 2005-6 STC 733. It is paragraph 20 and 14. Very important judgment, my Lord.
Yes.
And another judgment.
Today.
Don't be amused. I am trying my best.
Don't use such expression. We are here to listen to you. Why should we be amiss?
But Mumbai International Private Limited, Mumbai International Airport Private Limited, a regency regarding reported in 2010, 7 SCC 417. It reported, my Lord, the relevant paragraph is 13, 15.
Give all the judgments. Let us see. We'll hear you tomorrow. Let us read the whatever you are giving. Let him give. You give her also.
My Lord, I am giving the food. Why this food is bad? Defect of party.
Just give us which paragraph you are referring to. In this case.
I am giving my paragraph.
Unnecessary. You are giving these judgments as if
13 and 15.
As if you are re-arguing a matter. Anyway, just let us have a look at it.
Specifically fixed for on the point of maintainability of the review application.
Yes.
Maybe.
We can't be allowed to take this.
How is it? How is it?
I say this review petition is not in form. Lordship kindly sees the second appeal, Lordship, was filed by a different advocate on record. Now, Lordship, my learned senior friend was not even present at the time of argument also. Now, without taking a no objection from the erstwhile advocate, he cannot file this review application. In fact, the Supreme Court has deprecated this practice. Lordship kindly sees this judgment. Paragraph 1.
Yes, without NOC, it cannot be.
Lordship kindly sees paragraph 1. Lordship, this is reported in 1997.
1997.
Volume 9. Supreme Court cases
736.
Lordship kindly comes to page 737. The portion which has been quoted. It is, Lordship, passed in review petition number 2670 of 1996 in CA number 1867 of 1992, a bench of 3 judges, to which one of us was a member, has held as under. The record of the appeal indicates that such and such was the advocate on record when the appeal was heard and decided on merit. The review petition has been filed by Sri such and such, who was neither an arguing counsel when the appeal was heard, nor was he present at the time of arguments. It is unknown on what basis he has written grounds in the review application, as if it is a rehearing of an appeal against our order. He did not confine to the scope of review. It would not be in the interest of the profession to permit such a practice. That apart, he has not obtained no objection certificate from the advocate on record in the appeal, in spite of the fact that the registry had informed him about the requirement of doing so. Filing of the no objection certificate would be the basis for him to come on record. Otherwise, the advocate on record is answerable to the court. The failure to obtain no objection certificate from the erstwhile counsel has disentitled him to file this review application. Even otherwise, the review petition has no merit. It is an attempt to re-argue the matter on merits. This is exactly what is happening here, Lordship.
I was hauled up by court for doing this once. Long time.
That point is otherwise. Because one matter is continuing in the midst of another advocate appear and file the review application. That is why
No. Please read before you make a submission. That's not the circumstance. Review cannot be filed without NOC. Either same lawyer has to subscribe to the Wakalatnama, file the pleadings, or he has to give NOC. Otherwise, it is not maintained. That's a settled law. I told you, I was hauled up in court for doing this once. I remember in the first year of my practice. Terribly.
I have filed this because the matter was disposed of. Thereafter, I filed this.
Review is always filed after disposed of. Review is never filed before disposed of.
No, midst of any.
If that is a fact,
because the interlocutory order that cannot be.
That is not a fact here. That's not a fact.
Then I go through it. Then I'm not.
This is a very settled law, sir.
Yes. Obviously, I am not disputing, but I go through it.
He'll read it for the past. Give him. It's not
right. Settled law, I cannot deny. I will just obey, bow down, my lord.
But in fact, that judgment of the Patna High Court also, well, anyway, you have a Supreme Court judgment not required. In that case, what we had done is we had filed a review, and the court came down heavily. It was very new in that time. So I remember his proposition very well.
Yes, my lord.
I was let off, but then
bow down, your lordship, and I go through it, but then my lord.
Just go through it. Tomorrow we'll.
Yes. Not today.
for short passover, my lord, Mr.
And we should be sure. On the last occasion, the report has been filed by the chairman of the district primary school. And I will take a step that this report was taken and again.
Although you were not here. On the last day when it was taken up, you were not here. No. Anyway, you are for?
No, I am with him in this matter. Let us file the exception and kindly take it another day because he is taking time.
The learned advocate for the applicant seeks an adjournment for filing an exception to the report submitted by the DPSC Hooghly. Same. So in common order, you're filing exception in all. Give one by one, give.
Yes.
One by one, give.
That is 9.
9. Her file में डालो निकाल के. Put it in the file separately. No, but put it. Let him put it in. Tally the number before you place it in the report.
Okay.
11.
87. 89. 52. Seven. सब एक्शन में बात है एक मुझसे item number 18
না 17 তোমারটা হয়ে গেছে
80-70
Yes, he wanted adjournment. They have kept it on 24.
আমরা ফাইল করেছি কপি আমাদের দেওয়া
copy I have received.
I am appearing for the petitioners that matter, Your Lordship, 27th of January. Order kindly sees in terms of the Supreme Court decision, Your Lordship was pleased to direct my learned senior brother to take instruction.
Yeah.
তাতে তার লাগবে হ্যাঁ সিঙ্গেল অর্ডার হবে একশো বাহাত্তর তোলা যাচ্ছে 172 আছে 172 ডাবল পৃষ্টি 172
যেটা ওই যে हाँ हाँ
কে আছেন আপনি আছেন
What any instructions?
After 1st December 2025, Supreme Court, paragraph 7 said that subject to further subject to granting post-retirement benefits, including pension by completing the pension service of the respondent 10 years from today, there should be stay of operation of the MP in order dated 1st August 25 passed by the Division Bench High Court Calcutta in WPST number 172 of 2024. Let us wait for the final decision. Kindly see the paragraph 7. Kindly see and in so far Gita Naskar is concerned.
So this is the later order in that same case. This is the order we have considered.
No. And 8 January 2026, Gita Naskar.
judge সাহেব বলছে ডিসেম্বরে তুমি ওটা দেখিয়েছো এটা একই অর্ডার হয়েছে
Both
the order has been considered in earlier order.
The same thing, the petitioner shall and the subject to the same, there shall be stay of the impugn order. Gita Naskar.
Subject to payment of pension for treating 10 years.
10 years.
That's what we are saying. In this case also, why can't you do the same thing? Why you want to take a different stand for them? That is what we are asking you. And how you can take a different stand?
No, let us wait for the decision, final decision of the Supreme Court, nothing more. The whatever order has been passed by your lordship, that may be passed in this case, but subject to the let us wait for the final decision of the Supreme Court.
8126.
Can you see the WPST number in both the cases have been mentioned?
Yes, 240 and there is 172.
240 Gita Naskar and another is
That is Hiralal Ghosh.
Hiralal Ghosh.
So what was the direction in those cases? Gita Naskar and Hiralal Ghosh? To pay, to count the entire period?
Yes, entire period. Before regularization. Gita Naskar, my lord, kindly said, in spite of such judgment, preferably, especially director, you will also kindly director. Kindly see the Gita Naskar judgment. Last paragraph 21. Paragraph 21. Gita Naskar. Excuse me, madam, there is some marking is there.
আমার কাছে আছে, দেবো? কি জানো স্কোর?
I got 17, no, 21. 21.
সেকেন্ড কি জানো score? আমি ওটা বলি। হ্যাঁ, এটা তোমার এন্টারটা আমি এখন চাইছি না। আমি যদি ছাড়ো, আবার একটা দাও, সেটাই তো বলতে চাইছি। তারপরে সাবজেক্ট টু রেজাল্ট অফ দ্য সুপ্রিম কোর্ট জাজমেন্ট ওটা হবে। সাহেব তো সেটাই রেকর্ড করেছে আগে থেকে।
Only was, but only 10 years minimum pension. And subtract, your lordship directed them from the date of initial.
So that is why last order we have
দেখোই last order
framed that question that since you are there, you have confined your appeal only to this extent.
correct.
That for 10 years we will give, beyond that we will not. So if you have, that is your stand, then you take the same stand in everybody's case. Where is the question of waiting or anything like?
Only by minimum pension,
Yes,
minimum pension.
yes.
That is the judgment.
That is what we have recorded last order. Please read our last order.
Please.
Yes, sir.
Has not seen. হ্যাঁ, দেখো কি অর্ডারটা দিয়েছে, তোমাকে ইনস্ট্রাকশন দিতে বলেছে তুমি আপাতত এটা ছাড়ো, তারপর ওটা সাবজেক্ট রেজাল্ট অফ দ্য সুপ্রিম কোর্ট ডিসিশন।
Therefore, we asked you to take instruction from the finance secretary because the state has taken.
I have sent it to the finance secretary to the informant that immediately get an information for the government advocate for the.
No, we are interested. See, we can pass any order today, taking into view all these things, but we are interested. If your secretary says that yes, we are going to take the same stand, that will resolve all the cases which are coming in similar nature. Unnecessarily passing the same order and then going there getting the same order. It is a pointless exercise.
Unnecessary wastage of valuable time.
Of valuable time, your resources, the petitioners are unnecessarily having to go there.
Another SLP has to be filed.
And in all the, because in 2 cases the same order has been passed. So therefore, we ask you that you take instruction. This can be uniformly, it can be applied to all the persons.
All the persons, or at least minimum pension.
Yes, beyond that, whatever is decided, it will ultimately be decided in this case. As of today,
interim measure it can be done.
an interim measure, it can be allowed.
And interim measure, that order can be passed by your lordship, subject to the decision, final decision of the.
We want you to come forward and say something because we don't want to pass the same order in every case. You are obliged to maintain consistency. Therefore, if your secretary says no, then we will deal with it. What is the instruction we are asking?
But I have communicated, I am waiting for a reply. I
Come
have
back with instruction, then we will see. Otherwise, all these matters, so many cases are now coming up. We have passed the order in so many cases.
তোমার কমিউনিকেশন, oral communication.
all the time.
No, please take it up seriously because see, you have taken that stand before the apex.
জাজের এই অর্ডারটা দিয়ে
At least tell us what is the instruction. Come with instruction.
And then I had a talk by WhatsApp message and.
No, you seek instructions properly.
In writing.
Yes.
That would be better.
AGP submits that he has not No, before the apex court also they are not paying.
No. In spite of expiry of that 2 months. In December, today we are on February, middle of February.
2nd March.
That is why I am paying for 2 weeks from today.
You want us to press them?
Let it be. হবে দুই সপ্তাহ পরে হবে আচ্ছা let it be 3 কত
2nd March.
let it be it is in the top, let it be on
Yes, same position.
2nd March top লিখে রাখ top লিখে রাখ হ্যাঁ
much obliged.
Item number 19 top.
Let's hope for the best.
2nd March. No, because see, it will resolve.
Yes, there are some candidates.
Yes.
They are waiting for.
We know it has to
At least I have already on a file.
It has to.
Yes, much obliged.
Malad, this matter, item number 9. And I'm very sorry to say, Malad, matter is up to 2010.
We are also very sorry to see that it is of 2010.
Yes.
Nobody is happy to see that it is of 2010.
Nobody said. Yes. Now, my lord, already an interim order that was passed on earlier occasion when the matter was moved. And my lord, eventually, my lord, on the last occasion also, my lord was kind enough to pass another interim order. My lord, restraining my lord, the inquiring authority to proceed any further because of the earlier interim order already there. Now, my lord, what I say today, my lord, that despite my all efforts, my lord, still today, my lord, I have not yet received any instruction. Instruction specifically, what failed from your lordship is that actually what happened when the inquiry was, my lord, done in 2001 or 2002, and show cause notices served upon him in 2009 or 10, and the proceeding started in 2010 by filing writ petition challenging the same. Why such a delay? I think it failed from your lordship, my lord. Then, my lord, I tried to inquire the matter. The file is now, I am told that Shastro. But, my lord, director, deputy director, my lord, I have tried my level best. My lord, I have not yet received any instruction. I say, kindly, my lord, give me 1 week more time. If no instruction received, then, my lord, on the basis of the, my lord, the whatever the my lord, they have submitted or their amendments they are in, lordship, kindly, my lord.
The Leonard AAG.
Banerjee, some medical reason he is not available today. By kindly not today this matter. Not today.
I am filing my affidavit now.
Substitution was also to be filed.
Yes, Lordship.
Why? What happened?
I don't have
Petitioner
any
number
knowledge
3.
in that matter.
Huh?
I don't have any knowledge in that matter.
How many writ petitioners are there? How many writ petitioners? Eight. Copy of opposition has been served on the petitioner's advocate.
I'm appealing for the Public Service Commission, Lordship.
Kindly see.
Lordship, on the last occasion, Lordship directed me to take instruction on the revised list. Due to the non-joining candidates, a list has been published where the name of the petitioner was not there. Then I have informed them. Accordingly, the name revised list has been revised and the candidate's name has been recommended.
But till that matter, I have not kept there because that is not featured. The last occasion, my lord, is remember, I handed over. Thereafter, my lord, the last occasion, my lord, I handed over a list.
My latest instruction is on 6th February 26. Her name has been recommended in the revised list, Lordship.
But that's not stated here.
This instruction was earlier, Lordship.
So therefore, it's
Yes,
not in
yes.
this.
Yes, it is written here that it will be done, but
Where is that?
subsequently it
Where
has
is
been-
that? Last paragraph.
Yes, Lordship.
Will be taken. They have said.
Yes,
What
and
you
it has been
But it
taken,
was-
Lordship.
But take a
Lordship can
record
record my submission
submission.
because
It is on. It is in writing.
email, Lordship. I have received on my email. I have checked that her name has been recommended.
It will be kind
In
enough.
the revised list, her name is there, Lordship.
My lord, it will be kind enough. May I take my instruction? Give me 5 minutes more time. May I take?
Please.
That will
Because-
be more.
Do it, but it is in writing. Come
Yes,
back at 2 p.m. Come back at 2 p.m. You take instruction.
Lordship,
Come back at 2 p.m.
I can take printout from my email.
Yes, take that also.
Because yesterday I have asked whether revised
Come
list
back
has
at 2
been-
p.m.
Lordship,
Both of you sort it out, then it can be.
Yes,
Yes.
I can show him the email also. which-
Therefore, we have-
No. I believe you. I believe
Once
you.
it is in writing, why?
Yes,
they will
I,
not?
no. This is not question about this.
Just
please.
let them do it. Whatever you want to do it at 2 p.m.
Yes. Kindly dispose it of the.
Yes, just find
It's a
out.
good news for.
Very good for you. Very good for you. Yes.
Grateful.
Grateful, madam.
My advocate are just.
You have better sense prevails over them also. You have to appreciate.
But that I have to challenge. Thereafter they acknowledge that she is entitled 2 marks. Thereafter my marks become 276. But in the meanwhile, due to some non-joining post, article rule
Due
of
to the non-joining post, she has succeeded, Lordship.
Whatever is her performance.
yes.
Without changing the.
Yes. But my lord, it will be kind enough. My advocate on record instructed me that not yet she received it, but my lord, kindly.
I have checked myself, Lordship. I can show him.
Come back at 2 p.m.
Yes.
You come with that printout.
Lordship.
Yes. Give me a copy. Give me a copy. Grateful, my lord.
Item number 22.
This is that matter, my lord. Medical incapacity. Compassionate appointment on the ground of medical incapacity.
Oh, where they were delaying the declaration of incapacitation. That matters. Good for the state.
Yes, ma'am.
None appears for the respondent state matters.
Item number 23.
Well, I am for the petition, my lord. 23 to 27, my lord. Last occasion, your lordship was pleased to direct the learned advocate, Mr. Tapan Mukherjee, to produce the statute, my lord. It is for regularization of a service, my lord.
Produce the statute.
Statute. Your lordship was pleased to direct the learned advocate for the state.
Oh, executive instructions regarding civil defense volunteer.
My lord. some documents from order direction. So, but,
You have seen our order of 13 January.
we wanted what is the source of equipment of civic different color here? But I found that the main question is not being answered for this one. After the big time so that I can get complete information. And you can give it what it is kind of what more than please. That is it. We are coming under the but homework there is a separate study.
God is under a statute. They are not getting the privilege which civil defense volunteer is getting. Therefore, we wanted to know on how they are.
What is the executive order?
Yes, how they are better placed than the statutory entity. That is what we are trying to ascertain. As the
way of supplementary affidavit. Today, that is the supplementary affidavit.
what is the
matter
consequence of such second paragraph?
Yes, my lord, I will, my lord, kindly turn page
No, just
number 3.
refresh, please refresh. What is the background?
My lord, what is the background, my lord? Kindly turn, my lord, page number 40. This advertisement start from page number 39, my lord. This matter is all about, my lord, appointment in the post of staff nurse grade 2. There is a provision in the advertisement itself that I just read the note portion. The vacancies reserved for physically handicapped candidate will be treated as unreserved in case of non-availability of qualified candidate. What is that, RPWD Act 2016, right of person with disability 2016. It says, suppose in a accrued year, on the specific year, some seat is reserved for the physically handicapped candidate. If that physically handicapped candidate is not available,
Oh, then it has to change. The criteria has to change.
Then that seat will be converted
To the
unreserved.
other category of
Yes.
PWD, not unreserved. It will go to the other category of PWD.
Other category first.
Yes.
If that is not available, then
yes.
unreserved.
Then it will be unreserved.
Unreserved.
Yes.
That is mentioned.
That is the law.
That is the law. And
Yes.
my lord, year to year basis, my lord, in our state, my lord, there is a commissioner who, my lord,
Commissioner of Persons with Disabilities. Yes.
who
This
is
is a statutory
responsible-
authority.
Yes, my lord, who is responsible for whether the person with disability they get appropriate reservation.
What is
or
the
not.
date of the result? First result?
First, overall performance, that is published on 2nd December 2022, page number 131 of my writ petition.
What page?
131. What happened, my lord?
So there, you are claiming
I am a successful candidate. My name featured, my lord, what happened, my lord? Suppose, my lord, there are X number of seats. They will publish X plus Y number of candidates of our performance.
This is just a merit list,
Just a merit list. Suppose, my lord, there
not
is a,
select list.
this is a merit list, not select.
Not select list.
Yes, my lord.
Yes.
So merit list published in the year 2nd February 2022. That is
2nd December.
sorry, 2nd December 2022, page number 131.
Yes.
Thereafter, my lord, from that list, time to time, they publish the panel. First panel, they according to their requirement, they took the candidate from that merit list. That is the reservoir, my lord. I could say that is the reservoir.
And what is the life of this merit list?
Obviously, my lord,
1 year.
1 year or something, my lord. So,
No,
my lord,
no, is there any indication in the advertisement?
not mentioned in the advertisement.
So then 1 year.
Might
There is
be
nothing.
the
You are the petitioner, we are asking you.
1 year usually in our state, but it is not mentioned in the advertisement.
See, either there is a indication in the rule or there is an indication in the advertisement.
1 year.
If there is no indication, then it will be 1 year. That is the law. So if
Yes,
there is
yes.
no indication, then it is 1 year.
1 year.
Very well. So it is valid till December 23.
My lord.
2nd December 23.
No, my lord. With my lord, thereafter, my lord, what happened? That's why, my lord, I came with this supplementary affidavit. What happened, my lord? First panel, that is from overall performance, that list, they took the first panel in the year, some of the year in the 2023. But in the year 2024, they took other candidate in the way of second panel.
From this merit list?
From this merit list.
In 24?
24.
So that is what you have filed today?
That, my lord.
That you have filed today?
Yes, my lord. Some of the panel, my lord.
So your name is still not there?
Still not there because of non-conversion. Because of that, they says if
and you, how many petitioners?
Here, my lord, 7 petitioners.
All are of which category?
My lord, kindly turn, my lord. All are your category candidates.
All you are.
All are you are. And my lord, kindly turn page number 58 of the supplementary affidavit. My lord, I made a tabular chart of all the candidates. Because of that, it's a bulky one. So for that reason, my lord, I made a tabular chart of all the petitioner marks.
And what is the cutoff under UR?
My lord, UR category. My lord, kindly turn page number 3. He is the last candidate.
Who?
Suchisri Chattopadhyay.
Which serial?
Page 3. Suchisri.
30, serial 30.
Serial number 30. Got it, my lord?
Yes.
Suchisri, my lord.
So cutoff is 63.15.
63.15, my lord. That is in usual term. Because of that, without non-conversion.
As it is.
As it is.
Yes.
Kindly turn page number 48. Kindly turn page number 48. This is overall performance. I gave first page because this is the bulky one. So that's why, my lord, relevant portion, my lord, I just give it.
That you have given at page 58. You have.
My lord, kindly turn page number 49. The Suchisri Chattopadhyay, my lord, 1404. That is serial number. Got it, my lord? Overall performance. In overall performance, Suchisri, the unreserved last candidate, she is Suchisri Chattopadhyay, page number 49, 1404.
So you are showing that they are next in line.
Next in the queue.
Yes.
And not only that, my lord, I made a tabular chart which is annexed with my supplementary page number 54, and which is and it gave a clear picture that we are being a successful candidate, we are entitled to that convert seat. And not only that, my lord, I will show from their affidavit in opposition, one page, my lord. From that page, it will be evident they are obliged to convert it. Page number 54. Suppose serial number 1405. appointed in first panel, suppose the next candidate, because my lord is well aware of
This panel that you have annexed, it is of which date? You are saying it is of 24?
which panel, my lord? The
Where
first
is-
panel.
No, the today's supplementary affidavit panel. You said it is published in 24. Where is the date?
No, page 3. My lord, kindly see page 3, page 3, bottom portion. My lord, it is, my lord, got it, my lord?
Yes.
My lord, page 3, bottom portion, my lord. My lord, kindly in corner, it is signed and, my lord, got it?
No, that
Page
is.
3, bottom.
Yes, we have got what you are saying. It says there is a signature bearing a date 5/3/24.
Yes, my lord. My lord, got it, my lord?
But that is the only page which has a date of 24 inscribed on it. All the other pages are of July 23.
That is first panel. My lord, my lord,
From
kindly-
page 4, the first panel starts.
Yes, yes. My lord, because other candidate, they got in the unreserved category for that reason. My lord, kindly see page 4, that is 2023 dated.
But
And-
you have not made any statement in the affidavit that it is of 24. So this document is in support of which statement?
My lord, they have not mentioned. My lord,
Then how it can be accepted, sir?
my lord, this is mentioned itself in that.
We don't know.
My lord,
We don't know.
This is evident from.
Sir, you know
evident
better.
from that.
You know better.
Yes, my lord. If my lord,
A document, unless it is in support of a pleading, a document itself
My
will
lord,
be considered in a writ proceeding.
my lord, it is evident from the PT.
No, it is not. To us, it is not. We can't see it unless you say so.
My lord, kindly see because of that in the bottom.
Please,
portion.
the law of pleading is
Yes,
by
yes.
now well settled in a writ proceeding. You have to make a specific averment, and in support of the specific averment, you have to annex a document. Merely by throwing a document in the court, it will not suffice.
Yes, yes. I bow down
So
for
this
that.
is not an affidavit.
My lord, I
This
bow
is
down
no
for-
affidavit.
I bow down for that, my lord. But my lord, implied pleading, my lord.
We will not go by any such implication.
My lord, it is evident from
You
the.
are trying to say something that
Yes,
look,
I bow down. I bow
which is very contrary to what we expect, and we don't know under what circumstances if it has been done. You are saying no, it was 1 year, but they have published a subsequent panel in 24, but there is no averment. Then how we have to accept this?
It is evident from the signature itself.
If that is all you want to say, then nothing else.
So then, my lord, give me another opportunity.
What is this? This is the nothing.
But,
This is no affidavit.
my lord, another opportunity.
The affidavit does not contain any averment. You to take instruction.
The death took place in 1992. And
Death took place in
judgment of the Arjun Kumar Soren, that cannot be made applicable here. In that case, Arjun Kumar Pai, the applicant's mother died. That's a transfer application. But here, mother is alive. But because of her age, she could not be continued. And Arjun Kumar Soren,
So he still has to wait for
No.
something else to happen.
No, but can you see? Finding by the Learned Tribunal.
Anyway, he's not here, then let him be here first. Not today.
Get to work.
Item number 30.
Like item number 30 on the petition paid for not today. Like look at petition, could the medical treatment today for the go to the doctor, my lord, tell not to the not come to the not today, my lord.
Not today. 31.
My lord, I may be allowed to appear virtually in 31, my lord, for the petitioner.
You are welcome.
My lord, it is that matter, my lord, where
You
my
are
lord
welcome
direct,
to appear online.
grateful, my lord, grateful. My lord, in this matter, my lord directed that matter, my lord, the remuneration of the casual workers, my lord.
Oh yes, they said it was being done. What
My lord,
happened?
they have, my lord, given the area, but my lord, I find that the enhanced remuneration, my lord, they are not giving. Area, my lord, they have calculated up to September 2025.
Yes.
And that area has been paid only on, my lord.
Can one is for what purpose?
Not today. Can one, my lord, directed that to file an application since, my lord, though time was not fixed. That is why, my lord's on last occasion, my lord will find my lord's last order dated 22nd of December 2025, directing them to pay by 30th January. The area has been paid, but the enhanced salary, my lord, has not been paid. Till now, I am getting, my lord, 8,500. Whereas, my lord will
No,
find from the
what see what is the can? Come to the
Yes, my
can,
lord.
forget about orders.
Yes, my lord. Can was for, my lord, since in the, my lord, order, my lord.
Pass an appropriate order modifying the judgment.
Yes. My lord, since the time limit was
Incorporate a
not
shortened
fixed.
time.
And,
So what is the order? What is the order we passed in the writ proceeding?
my lord, it is annexed in the, my lord. Can, my lord. Last.
Retreat was allowed.
My lord, since the time limit was fixed, my lord, for granting. So I mentioned and, my lord, on, my lord, 18/9/2025, annexed this order. My lord, last page of the CAN application, my lord, passed order on 18th of September 2025. My lord, directing to, my lord, file an application. And that is why, my lord, pursuant to my lord's leave, my lord, I filed this application. Upon serving copy to my lord, senior advocate, my lord, Mr. Mukherjee.
And what has been paid to him?
My lord, on my lord, 4th of November 2025.
And partly to my directions, there is a calculation made and forwarded to the government for financial approval. Last 17,43,794.
The area's difference, perhaps he is saying that area's difference has been paid.
Yes.
So what remains? Now the enhanced rate has to be paid to him currently. Yes.
Well,
No.
up to September they have calculated.
Not if there is delay from the date of payment. Yes.
Up to September 2025, my lord, they have calculated. And paid on, my lord, only paid on, my lord, on 8th of January 2020.
Can you please not speak side by side? You are appearing virtually. That means you will continuously keep speaking.
My lord, I'm apology, my lord.
Yes.
And 6% interest comes to 1,04,627. The principal amount is 17 lakh.
We are asking you what has been paid to him. What component you have paid to him and what remains as per the order?
My last communication that I have received that it was sent December 2025. That according to my lord's directions, calculation was made and forwarded to the.
No, but he is saying that area's difference has been paid. So then tell us what remains.
My lord, first of all, my lord, they have calculated up to September 2025. The amount, my lord, up to interest calculated up to September, and that has been paid, my lord, in 28th January 2026, and my lord, after
8
September,
January.
8 January.
Yes.
My lord, calculated in September, my lord, paid in January. My lord, 3 months later, October, November, December, January. My lord, almost 4 months after, paid. And that to my lord, from October till now, the annual salary has not been given. Only 8,500, my lord, I am getting.
October 25 till now, enhanced salary has not been given.
Not given one.
So therefore, there is no issue of now fixing any time. If they have not complied, then they will face the contempt. If they have not
So grateful,
complied
my
in totality, they will face the contempt.
According to the calculation made by the government, 17,43,794 has been paid, plus 1,04,627 has been paid.
No, see, we are not interested in the amount. 17 lakhs plus 1 lakh, about 20 lakhs you are saying. But we are only interested whether enhanced salary is being paid or not.
Indian salary has been paid up to the, in terms of the pilot's order.
So therefore, now they will do it. If there is any shortcoming, you can come. There is no question of now any time frame being imposed.
My lord, they are not paying the the enhanced salary.
So therefore,
my
this
lord,
writ petition should continue every month till your payment is received, or every month.
No, my lord. My
Therefore,
lord,
we are saying where's the question of fixing a time frame now? They have
No,
complied, they have made payments. If there is any shortcoming, you can move for contempt.
Yes, my lord.
The learned advocate for the petitioner submits. Yes, we have said that you may take out appropriate proceedings.
Grateful, my lord. Grateful.
He said that time limit is not fixed. State Council was appearing is
32.
I am preparing the petition. Yes, affidavit has been filed, my lord. I have challenged the order, my lord, passed by the joint secretary, my lord, that has been dismissed. That is at page 67.
What has been rejected?
Compassionate appointment prayer has been rejected, that you have filed the application in proper forma out of time. That was the only ground of statement. And my lord, I have annexed, they have also admitted that we are on plain paper, I have submitted within 3 months from the date of death.
It is the date of death.
The date of.
What is the date of death?
My lord, the date of death is, my lord, it is
Sometime
3/11/2015. My lord, the page number 45 is the, my lord, death certificate.
Yes, and you made your plain paper application on?
Under plain paper application on, my lord, for page 46. My lord has, on the earlier occasion, my lord asked for the my lord, translation.
That's why we are asking you. We have
My lord,
recorded.
Okay. My lord, my lord, these has been, my lord, already translated, my lord, by the my lord, respondents in their affidavit in opposition. My lord, kindly see page 18A.
Opposition.
That is the other two.
Opposition.
Opposition.
Page 18.
18A. 18 is the my lord copy and 18A is the translation. And the rest two annexures, my lord, they are the only the consent letters, my lord. I have, my lord, translated the two documents.
What is the number of EMP? What is the date of EMP 26?
My lord, 113.
13?
13 2016. So, my lord, this application I have noted, my lord, this application has been filed on 2/3/2016, my lord, for the first time. My lord, kindly sees the receiving date 2/3/2016, just one day after the publication of the notification.
So it has to be considered under 26 EMP.
26, my lord, after that, my lord, the 10 BB, my lord, has been incorporated in the act on 1st. My lord, it should have been, my lord, considered, my lord, that this should be made because, my lord, in the affidavit in opposition they have, my lord, filed, my lord, kindly sees their annexure, which reveals, my lord, the superintending engineer has returned, my lord, kindly see the page 21 of annexure R3.
We are not asking, we are asking you.
My lord.
It's your case that it has to be considered under
26. Under BB, we should be, my lord, given the provided the, my lord, opportunity to furnish that, and they should advise us, my lord, what is the, my lord, proper procedure. My lord has delivered a judgment on this, my lord. I have also got the copy, my lord, of that judgment. My lord, just, my lord.
No, this is not a pending or undisposed case. Those are judgments we have rendered in undisposed case.
My lord, beyond, my lord, rejection, my lord, has been set aside by your lordships, my lord, on the ground of delay in application in form. My lord, kindly sees, my lord, the.
Yeah, this is not an issue of delay. They are saying that pro forma has not been filed.
Yes, that is has been, my lord, the. In that case also, my lord, they have stated that that pro forma has filed after the period of 2 years.
So after 1/3/2016, what is the time limit for filing a pro forma application?
My lord, time limit, my lord, in my submission, my lord, it may be, my lord, 2 years, as per their interpretation. But what I am submitting, my lord, is not that. I am submitting, my lord, why this, my lord, this amendment has been brought in. My lord, what is the, my lord, logic of brought in the amendment?
You are telling us what we have decided. You are telling us what we have decided. We are saying there is a slight nuance in your case. Their objection is non-filing of an application on pro forma. They are not saying that this letter you have not submitted.
No, no.
Because they have placed it on record. So therefore, you look at the 26 EMP once again. Note C under para 6C has been deleted. Therefore, we are asking you. Where is 251?
251 is also annexed.
Yes.
At page 32. I have also annexed. My lord, it is. I have also annexed in the my writ petition. Page number 80. No, page number 70.
Now, there is one more important amendment from your point of view. At the third page of 26 EMP, the second will come back. You have a look. That pro forma application requirement, it has been substantially amended. Therefore, we are telling you. And you are still within 6 months. So just have a look.
It appealed to your lordship, take up 32 on some other date. Item 32 was taken up just for a few minutes.
Just here. B. पहले 3 p.m. 2 p.m.
But 32 was taken up just before rising. Could it be taken up on some other date? One content matter is fixed in the other.
When do you want it?
Any day that's
No, tomorrow, Monday, Tuesday, you tell us.
tomorrow.
Not today.
Not today. No, my lord, kindly make it next week. Next week.
Very well. As spread by London State Council, list on Tuesday's date.
Order. Order.
Item number 21, Lordship, I've got the printouts.
Will be called. Wait, let it be called. After the fixed matters.
Item number 34 and 35.
But in both the matters, my lord, these are identical matters. I appear for the petitioners. My lord.
Yes.
I appear for the, this is my lord, pertaining to regularization of the Ayush doctors, my lord, who have been serving and Ayush, who have been serving the state of West Bengal on contractual basis for my lord, about 15 years. Now, my lord, yes, 12, 13 years, about 15 years, 12, 13 years. All of them. Now, they fulfill the exception criteria as as have been laid down in Uma Devi's case. They have been, all of them have fulfilled. They have undergone through a selection test. Vacancies were available, and they have served for more than 10 years against sanctioned post. Against sanctioned post. Now, these are the issues. The tribunal initially, first round of litigation, in the first round of litigation, tribunal remitted the matter before the concerned authority for taking a decision and passing a reasoned order. Now that in fact did not.
Your Lordship, on behalf of the state, the opposition was to be filed. This is
to be filed.
The affidavit in opposition, Your Lordship. It was served upon the petitioner, but it was not.
But in fact, on the last occasion, it was not traced out from the court records. That's why they were directed to.
You had not filed it earlier.
Lordship.
Please to be.
So many things have been filed. By opposition.
Not only opposition and reply, my lord.
Why are there so many affidavits? What else has been filed?
No, only
one, number 5. What are these 5 affidavits?
There are two matters, 34 and 35.
74. Oh, affidavit of service.
Yes.
3 affidavit of service. Why 3? So there is only an opposition and
yes. Issues are very simple. If I am permitted to proceed, the petitioners are seeking for regularization of their services from contractual engagement. Now, the concerned authority in the first round of litigation were directed to pass a reasoned order. But the reasoned order did not favor the petitioner. Thereafter, the second round of litigation was initiated by the petitioners. Now, thing is this, since they have been discharging the duties with the satisfaction of the authorities, only nomenclature is troubling. That is contractual engagement. And in the reasoned order passed by the authority concerned, has taken the only point that since you are contractual appointee, you cannot be regularized.
Your Lordship, I'm led by Mr. Jayanto Shamanto. I'm led by Mr. Jayanto Shamanto on behalf of the state, Your Lordship. My senior is stuck in court number 12 in a contempt matter, Your Lordship. I am praying for not today only.
Let him come. In the meantime, he will come.
Yes. Now, if Your Lordship kindly straight away comes to page 117. Contempt. 117. 117.
Where is the order passed in OA 881?
No. Just
Of 2018?
yes. But I am not Mr. Page 72, right? Page 72, if Your Lordship can. 21st March 2022.
Where is the order passed pursuant thereto?
Yes. Page 118. Communication. 117 is the communication forwarding letter. 118 is the order. In fact, immediately preceding page 116 is the order passed in the contempt, because contempt was initiated. 116, 17, and 18, if you Lordship.
Where have you stated the 11 persons who are regularized?
11 persons who are already regularized. Representation বলেছি page 95. Kindly have a look, Lord. This is order dated 31st March 2008, page 130. This is a memorandum of the government issued by the Joint Secretary. Yes. Now, Lord, kindly see, Lord, the impugned order dated 15th May 2025, last annexing. That is the impugned order. Yes.
Where is the advertisement prior to which you were, pursuant to which you were engaged?
Yes. Just a minute. Page 47. Twenty-ninth March 2012.
No, where is the advertisement we are asking?
Lord, in fact, Lord, this is the notice. Lord, kindly see, Lord, paragraph 2.
This is not a notice. Kindly see paragraph 3, sir, of this order. Page 47.
The committee will finalize the matter of advertisement indicating essential.
Where is that?
Advertisement. That's okay. Hmm? No, no, ওটা দেখতে চেয়েছেন advertisement. না আমরা দেখাতে পারবো কি advertisement-টা? Just a minute. Lord, if your lordship takes up the opposition filed by the state, Lord, no, date date 13 to 12 no 13. Lord, page 14 of the opposition. এটা কোন তো?
There is no reference to any sanctioned post.
Page 63, if your lordship kindly comes, of the writ petition. Page 63. Look. Lord, 5B.
This is the RTI. This will not. This will not.
This is RTI information.
Advertisement doesn't say that it was being done against.
Advertisement to the Lord, they were Lord, the contractual engagement Lord was made Lord, pressing them in a pay scale, with pay band. Your lordship sees, Lord. And Lord, total post, if your lordship sees, Lord, total post 28. Now, Lord, the reservation was also roster was also followed in publishing the advertisement. 28 post, if your lordship sees. Lord, if your lordship kindly have a look to the opposition, Lord, at Lord, page 8, Lord, last paragraph, what they have said. Lord, this is Lord, undisputed fact, Lord, in fact admitted by the state authorities. Lord, if your lordship sees, Lord, page 8, last paragraph. Yes, this is the part of paragraph I.
Which pleading you are referring?
Lord, affidavit in opposition.
Yes.
Page 8, last paragraph. Since the petitioner were not selected by the constitutional statutory body, West Bengal Health Recruitment Board, PSC, but by a departmental committee, their appointment is technically irregular regarding permanent status, though legal for contract purposes. Therefore, they do not fulfill the primary requirement either of the Umadevi, even the judgments passed in recent past, exception, appointment against sanctioned post via competent authority, or even the judgment passed in the recent past, they cannot claim parity with the regular recruits. So, Lord, admittedly, we have been accepted as irregular appointees. and the decision was taken by the state authorities that the department would constitute a selection committee. Accordingly, process of selection would be conducted. Now, in a similar situation, apart from Uma Devi, the exception as laid down in paragraph 53, I shall be placing reliance on that. Very recently, the Supreme Court, in identical matter, the same status, contractual, everything is same, wholly identical. The Supreme Court has come to a decision, that they should be regularized in a very recent judgment, latest judgment, that is reported in 2026 SCC Online SC 129. If your lordship kindly see, there is no difference at all between the persons involved in this case and the petitioners before your lordship. Kindly have a look. Citation টা বলে দিচ্ছি আমি। But if your lordship sees first paragraph 4.1, The 4.3 granted extensions from time to time. In our case also, same thing happened. Then the issues framed by the Honorable Court, Apex Court, at paragraph 8. Concurrent findings were against the petitioners, Lord. The Supreme Court reversed, single bench as well as the division bench. সেগুলো রেফার করে নিচ্ছে ইমপিউন জাজমেন্ট করে But the
Yes.
But paragraph 13.10, last but one page, paragraph 13.10 and concluding paragraph 14. These are two paragraphs that I am placing reliance on. And Umadevi was also taken into consideration. The mechanical application of Umadevi has been discarded by the Honorable Apex Court. And even if it is applied, we fall under the exception. If your Lordship sees Umadevi also, I have brought that decision. Since this is a constitution bench, that cannot be altered by the.
Come to 13.1 of this judgment. Last paragraph, last subparagraph, 13.1.
13.1.
Last subparagraph.
However, this court in Umadevi Supra clarified that the bar against invocation of the doctrine of legitimate expectation applies only to those temporary, contractual, or casual employees whose engagement was not preceded by a proper selection process in accordance with the extant rules. Consequently, where such engagement is made after following a due and lawful selection procedure, there is no absolute bar in law preventing such employees from invoking the doctrine of legitimate expectation. Now, Lord, possibly your lordships lordships are being troubled with the procedure of selection. Procedure of selection. If your lordship kindly sees the decision of the authority, because Lord, the selection.
Not troubled by anything. You wanted us to show us the exception. Therefore, we said exception has been recorded in this judgment itself.
That's correct. But if your lordship, just if I am permitted to show the paragraph 53 of Umadevi.
Yes, why not?
Yes, sir.
Appointment by a competent authority, duly qualified, continuing for more than 10 years without aid of any order of the court. What else?
Yes.
That
Yes,
is 53.
Yes. 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 So Lord, I also place my reliance on this paragraph, Lord.
And one-time exercise to be taken by the various authorities.
Yes.
But this is one-time exercise direction was for those who were already in service in 2006.
That's correct.
Yes.
That's correct.
You were not in service in 2006.
No, we were not. But the principle laid down in the in our case, the consideration would be for the first time. And in Bholanath's case, cited, my lord, just, my lord, a few minutes back, my lord. If your lordship sees, this is here the employees were engaged in 2012.
Yes,
like us.
we have seen that.
Yes, like us.
We have seen.
And my lord, your lordship is also aware of the decision of Jaggo. My lord, that is of
Jago, Dharam Singh, Bholanath.
Yes.
So now we are reminded of the earlier position. When I was that side, we were relying on these judgments.
No, my lord, these are very latest judgments, my lord, coming in the field. My lord,
It was the leading judgment of Punjab. Very old judgment.
Dharam.
No, this is the recent one. Old judgment.
M.L. Keshari was of 2010, possibly 2010.
Something like Pyara Singh or something.
Pyara Singh is of 92.
That is what I am saying.
Pyara Singh is of 92.
That is what I am saying.
The ad hoc cannot be replaced by ad hoc.
Yes.
That
No,
was
in that there is also something about
regularization. Yes, yes.
That our ad hocism should be avoided.
That's correct. That's correct. Then, Lord, there is a golden age. Everyone gets the regularization at that point of time. After Uma Devi, Lord, the regularization cases we tried to avoid, to accept. We tried to avoid.
We looked at the golden thread of Article 14 and 16,
yes,
which runs through everything.
So after Lord Uma Devi constitutional scheme, Lord backdoor entries, these concepts developed time to time.
They cannot be rewarded. That was the whole concept.
Yes.
Such persons who have gained entry cannot be rewarded by regularization.
That's correct, Lord. That's correct.
Now these three judgments are reconciling that situation
Lord.
with the earlier law,
Yes.
laying emphasis on para 53 that irregular, not illegal, then there is a scope.
Yes.
And what is irregular has been defined.
And Lord, they have also accepted that our appointment was at the most irregular, not illegal. They have admitted in their opposition. So very Lord, small issue. Lord, I am possibly Lord, fortified by the latest judgments of the Honorable Apex Court. And Lord, I leave up to your
What
Lordship.
is the result pursuant to the recruitment process? That process undertaken by the advertisement, where is the result? Anybody's appointment letter?
Yes.
Any merit list published? Any list published?
No. Individual appointment letter will. First week.
What happened? You have any merit
Yes,
list?
Lord, to page 48, your Lordship sees Lord, page 48.
40.
48. 48.
Where are you in this?
Lord Dr. Kuntal Ghoshberkar. नहीं इतने नहीं कहना
Where's your name?
Kuntal Thakur. Lord Moinak Banerjee is one of the petitioners, serial number 7.
Yes.
Now, Lord Kuntal Thakur.
How many petitioners are there?
Lord, in the in WPST 174, Lord, there are 9 petitioners.
So where are the 9 petitioners' name in this?
Go to page. No, don't দেখতে চাইছি। Lord, if your lordship takes up our affidavit in reply, Lord, he was Kuntol, Dr. Kuntol.
So this does not make sense. The advertisement you have thrown is of 2013. And how this engagement can be of 26, 2012? Advertisement is at page
Lord, in 3 phases, appointments were issued. Lord, advertisement was also issued in 3 phases.
No,
Now,
sir,
Lord,
you have shown page 14 of the opposition. Come to page 14.
Page?
All 28 vacancies were advertised in 2013. And you are saying on order of appointment or result of the appointment of June 2012. How can
just a minute. May I clarify this? I am just clarifying this.
Right.
Wait. No, no. এটা তো একটা সিঙ্গেল এখন ওজনের নাম কোথায় পাওয়া যাবে?
You filed a common representation.
Yes. Kunta. No, yes, no, separately. Representation was made separately pursuant to the order passed by the tribunal.
All the petitioners have filed the
Yes, my lord, as I find. Yes. There, my lord, your lordship would find, my lord, the who was given appointment on which date.
No, that's not the point. The point is, according to you, this and page 14 annexure R by 1 forms the basis. After R by 1, pursuant thereto, where is the result? How do we see that there was a regular process based on which you have been selected?
Yes. Now, my lord, yes. Lord, similar type of advertisement was issued in 2012. That is not annexed in the writ petition. Lord, pursuant to such advertisement, the selection committee selected the persons appearing at page 48. Now, Lord, here we can find 3-4 names of the writ petitioners. But I am just giving the names who were selected in pursuance of the advertisement published in 2012. Now, Lord, thereafter in 2013 also, the advertisement was issued, which has been annexed and shown to your lordship. আমাকে নামগুলো বল, এখানে কারা কারা ছিল? দেরি করলে কি করে হবে? বাস, বাস। But serial number 7 is one of the petitioners. Then 15 is one of the petitioners. 27 is also one of the petitioners. Yes. Or what is the vector? বল নামগুলো। আর appointment গুলো দেখা then kindly see page 51. Here I find one of the names of the petitioners. First one, Dr. Abdul Khalik Lashkar. First petitioner, Kuntal Ghosh, is appearing in our affidavit in reply at page 22. Page 24, another petitioner, Dr. Shubhobroto Roy.
This is of 2013.
Yes.
And some are of 2012.
Yes, because in 2012, another recruitment process was initiated. There, some of the petitioners were appointed on contractual basis, and in 2003, pursuant to advertisement, to 2013, some petitioners were appointed, and the extension order is also annexed. From time to time, extension was made, and there, I find all the names of the petitioners, and still till date, they are continuing.
And when they issued advertisement in the meantime for making regular appointments, how many appointments they made?
No, regular appointment. Advertisement. Fill up kota on instruction, I am saying, in 2018, there was an advertisement for regular selection.
28 posts.
31.
98 posts.
98 posts were filled.
After that recruitment, whether any sanctioned post is remaining vacant? Because you chose not to participate in that procedure.
They have not denied that there is no sanctioned post available till date.
They are saying you are not entitled, therefore they are not going into that. But the point is that you are appointed against sanctioned posts. That is your claim.
Right.
After your appointment, 5 years later, they conducted a recruitment process by the commission or recruitment board,
Recruitment
board, whichever is the competent authority. You challenge that advertisement, then you withdrew.
We did not press.
So you did not face the recruitment process. You were perhaps not confident that you will compete.
No, because our application was pending for regularization.
Oh, what? Subject to result, one can participate. It's very common. But you chose not to participate.
That's correct,
That is a concluded issue.
And we did not press the prayer.
Yes, you before the tribunal also you said yes, let it proceed. So now if the recruitment has been done and they have decided as a matter of policy to have regular appointees as well as contractual, then where you will go?
I would submit, subject to your lordship's kind.
If your anywhere specific assertion that even after that recruitment process, posts are lying vacant.
Reply bola আছে কি ব্যাপার? Contractually disturbed হবে, এটা তো আলাদা ইস্যু। রেগুলার অ্যাপয়েন্টমেন্টের পরে আরো স্যাংশন পোস্ট আছে, এটা কি আমরা কোথাও বলেছি? সেইটা রিপ্লাই কি বলা আছে? যেটা দর্শকরা জানতে চাইছে। Contractual post or the sanction post. So that is 20 post and sanction post. What the information that you are saying? 98 posts. That is 200. 20 posts. Not sanction. That's it. রিপ্লাইটা কবে? না না, সেটা ডেট, এটা আগে 2016 সেটার পরের গল্প। Through RTI information, we came to know that all contractual appointments were made against permanent vacancies.
28.
That's correct. But so contractual appointments, if were made against permanent vacancies, but in that case, these are to be taken as additional permanent post.
28 persons appointed on contract. The RTI says it was against vacancies. Thereafter, regular recruitment process in which 98 persons were appointed.
Right.
So therefore, after that, whether that 28 still exists, how do we know? Can't be presumption. You are seeking a direction. So where is the post we are asking? You have, from your submission, subject to what they may say.
Yes.
You have submitted that now in view of the law, Bhola case.
Yes.
Jago, Dharam Singh.
Yes.
You have continued for more than a decade. Your appointment is preceded by a process.
Yes, sir.
Inter se merit evaluated. It was against the sanction.
Absolutely.
You have continued for 10 years. Therefore, a direction should be issued.
Right.
It is the post. Because in intervening circumstances, the recruitment process.
Not,
if you chose not to participate in.
Lord, in another document, Lord, something is there, Lord. I want to clarify. Lord, in our affidavit in reply, page 49.
49.
Yes. Lord, this is after the regular vacancies were filled in 2018. Yeah. Lord, page 49 and 51. If your lordship sees, Lord. This is not only presumption, Lord. This can very well be, Lord, taken for granted that vacancies are available.
No, it cannot. This contractual extension, this does not mean that there is a sanction post.
Kindly see, Lord, months with
contractual employees have been posted at these establishments.
No, that's correct.
Does not mean against sanction post.
No, Lord, that's correct. Extended for a period of 12 months with effect from the date shown.
Must have made a statement somewhere that the sanction post exists after the recruitment process.
That would be better clarified by the state.
Oh, they have to make out your
No,
case.
no, not make out. But since, Lord, the matter is going on for about not.
You assailed the recruitment process in 2018. What was your case before the tribunal? That they will fill up the post, therefore where we will go?
Now kindly see the order once again.
We have seen the order.
Yes.
You have refused to press the application.
Because that was not the sole prayer, Lord. That was not the sole prayer. One prayer was not pressed. That is not the selection process was challenged. We said that we are not going to challenge that.
That is the only prayer by which you are affected. Because if they filled up the post, where you would go? That is why you challenged it. And then you said, since we are being continued, we are not challenging.
Because Lord, our main prayer, which was required to be adjudicated by the tribunal, whether we can be regularized or not. So, Lord, taking into consideration.
Nothing. You did not assail the recruitment process. You said for regularization, I will file representation. Tribunal said, go ahead. Nothing decided.
And Lord, in the
decided is you chose not to challenge the recruitment process. Your specific stand is stated in the order.
Lord,
they are not pressing the relief.
But Lord, in the
having abandoned that relief, now can you make a volte face against those posts? Does it exist? That is the issue we are trying to ascertain. You have.
I understand, Lord, what has fallen from your Lordship. Your Lordship, kindly see in the reasoned order, which was impugned in the second round of litigation before the tribunal, Lord, they have not said that since vacancies are not available, you
are saying you participated, you withdrew consciously, therefore there is no scope. What does that mean? You see the reason order. The point is, you see, before you can expect any relief, you will have to show to the court that there is a post available against which you can be regularized. Otherwise, the order will be of no use. And if there is no vacancy, whether there is existence of such a circumstance to direct for supernumerary post, we don't know.
Lord, may I just draw your Lordship's kind attention to page 118, that is the reasoned order.
118.
118 in the writ petition. On going through the prayers and all supporting documents submitted by the paragraph 3 of the first page dated 26 June 2023. On going through the prayers and all supporting documents submitted by the petitioners, it appears that the applicant who is working on contractual basis prayed for regularization of his service. On close checking of the petition, the observation is as follows. The petitioner applied for the post of senior Ayurvedic medical officer contractual following the notice where it was unequivocally stated engagement on contractual basis. The applicants were engaged by number so and so, so and so, so and so. Now, point number 4 of the said order states the engagement will not accrue any right for its renewal for re-engagement. Point number 6 states such engagement shall not entitle the candidate for any regular employment under the government. In the instant matter, the celebrated solemn judgment dated so and so passed in the Umadevi case being number so and so, wherein the Honorable Supreme Court of India, in connection with the claim of regularization of contractual workers, employees, observed that this classical position continues and a mandamus could not be.
Order does not throw any light on the court's query. You are unnecessarily reading that order.
No, but they did not say that since vacancies are not available, you cannot be accommodated.
Therefore, we should presume that there is a vacancy. So, unless you say in your application that even after the recruitment, there are posts available against which we can be appointed.
I understand.
Why they should say that?
I understand. What has fallen from your Lordship? Let me just check on a petition about the vacancies are available.
Please show us what you have said, where you have said that even after 18 there is a existence of 9 vacancies against which we can be regularized. Otherwise, your argument is just imagine if we pass a direction and there is no post, what will happen to you?
But even in that case, my lord, subject to your lordship's kind appreciation and consideration, my lord, Jaggo would help us.
No, it would not. There has to be a specific case on facts. We cannot issue a blanket order to do anything and everything. And Jago, you know what exercise, what jurisdiction was being exercised. It is explicit in the order.
142.
Yeah. So therefore, yeah, we have also seen the judgments.
No, I understand. Your lordship. In fact, my lord, in one matter, I was on the other side. Your lordship has referred that judgment. এখানে পেজ 10 এ তো অনেক কথা বলেছিস না ইন্টারভিউ
Because they have not accepted that you are appointed against sanction. Very unique stand. In their opposition, have they said anything that you are appointed against sanction post? Have they accepted this fact?
Lord, in opposition, Lord, if your lordship sees, Lord, if your lordship sees, Lord, page 8, last paragraph, I have already shown to your lordship what they have said. Since the petitioner were not selected, last paragraph of page 8, were not selected by the constitutional statutory body West Bengal Health Recruitment Board PSC, but by a departmental committee, their appointment is technically irregular regarding permanent status, though legal for contract purposes.
Now come to that page 9, paragraph B.
Page 9. Yes. With regard to the statements made in paragraph 4 of the said petition, I deny and dispute each and every allegation made therein, save and except what are matters of record. And I repeat and reiterate the statements made in paragraph 4 herein above. Further, it is denied that the petitioners fulfill the Uma Devi criteria. They were not appointed against substantive vacancies via a competent statutory authority. They were engaged by a departmental committee for a stopgap arrangement. So, paragraph 4, what they have said, kindly see paragraph 4.
No, this is a specific environment. That is why once we have seen, therefore we are asking you, from where are you making this submission? You are only saying that one place they have used the expression irregular, we are irregular, therefore we can be regularized.
Another point, Lord.
They have specifically stated
that is their
not
statement.
appointed against substantive vacancies.
That is their statement. But Lord, our RTI document says something else.
Yeah, I will not help you, sir. You know the law very.
Lord,
when affidavit is pitted against RTI information, which will prevail?
Lord, it is stated by the director of the.
Very well, you rely on that. And if it is a wrong information and in appeal it is set aside, then what will happen?
No appeal has been preferred by anybody.
So, which will prevail? That is why we are asking you. The information given by SPIO or an affidavit filed in a court proceeding.
কত নম্বর প্যারাগ্রাফ বলতো এটা কি বলেছে না কি বলেছে
Who is appearing for this case?
Your Lordship, he is in a prefix matter. It was also. It is a contempt matter, Your Lordship, before court number 12. Your Lordship, let the petitioner complete their submissions. The state shall make the submissions on the next day. Your Lordship.
Yes.
Your desires.
Lord, if your Lordship, Lord, kindly sees one thing, Lord, page 13 of the opposition, Lord, the affidavit part, Lord, that the statement made in paragraph 1 to 4 are true to my knowledge. And made those made in paragraph 5 to 10 are my respectful submission. So Lord, this is submission. So this cannot be taken, Lord, as gospel truth.
So where is that gospel truth that the post was like available and you are appointed against that?
In fact, Lord, I'm really, Lord, Lord, had I, Lord, procured that document, Lord, I would have been.
No, because you have come to the court.
I understand, Lord.
Case that is, you are seeking a
After filling up the
once you
vacancy.
once you have made your submission, trying to place your case within the four corners of the exception carved out in paragraph 53 of Umadevi, relying on these three judgments, the next issue is where are you to be regularized? You have to make submission on that with reference to some facts. Otherwise, if this is all, then we can ask them to make submission.
Lord, Lord, the queries, Lord, Lord, as expressed by your Lordship, Lord, that I cannot, because.
So then let's hear what they have to say. Your submission is over. Done it.
17. The 2 p.m. Lords.
No, let us see. It will be taken up. It will be taken up. We have any 2 p.m. on 14th? We have any 2 p.m. on 17th? We'll see. Let it.
Then 24th, Lord, next week.
24th, we are. I don't think this month there is any. There. All right, 24th.
24th.
My lord, item number 35 also.
Both here, both will come
The
together.
35 only difference, Lord. I am working as Ayurvedic medical officer, not senior Ayurvedic. That single petitioner.
एक काम करना सीनियर आयुर्वेदिक जो पोस्ट लिखे हैं वहां स्लैश करके व्हाट इज द अदर पोस्ट
Ayurvedic medical officer, not senior.
Ayurvedic medical officer.
A single petitioner. I am extremely grateful to my lord. 24th at 2 p.m. দুটোই
Yes, yes, 2 p.m.
Both the matters.
Both matters. Hey, Supriyo.
I am grateful to my
মাল লিস্টে কোথায় গেল?
How we consider that rules?
কি পর অর্ডারে আসবে?
Who is for the appellant?
None was there. Just hanging outside. In fact, Lordship will find there was a direction on the last occasion to make a NPS, with regard to NPS to make a party in this proceeding. I've made, and to be honest, in this aspect, the payment with regard to NPS has also been made. So,
Let him be here. We are adjourning it not today. We have some other matters at 2 p.m. If he is not here, tomorrow. Not today.
tomorrow at 2 p.m.
Yes, all right. Same position tomorrow. No order.
Is there? Saved.
Yes, sir. No, why sorry? We know that you have to
I
go.
appearing on behalf of the Life Insurance Corporation of India, as per my instruction, the last due from the NPS has already been disbursed.
He is saying it has been paid.
Yes, yes.
Now, there are, Lordship knows there are three aspects of the scenario as per the retired dues are concerned. One with regard to this admitted dues what the LIC ought to have been paid, which has been paid. Second is with regard to an payment from the Oriental. This is also part of the retired dues, which is still due and payable. And third with regard to the interest, which there was a direction from the trial bench, which they are contesting on. Now, with regard to the admitted claim is concerned, with regard to that, what they ought to have been paid, that has been paid as of yet. And what remains at the second stage, now it will come with the Oriental Insurance, who will be paying 50 lakhs.
Who is for the Oriental?
Your Lordship, I am appearing for the Oriental. Respondent number 3, Your Lordship. Oriental Insurance.
Is there? So no, she will find there's a admitted claim for which 50 lakhs ought to have been paid from the end of the Oriental Insurance. Now, for which LIC has already made running a group insurance, which has been already put forward. Now they have been hanging the same and make it repudiated on the ground that they have claimed it on a later date.
It stands repudiated.
Yes, that's their statement. That's their statement. What they have made.
Where is that statement?
In the supplementary affidavit, or she may have a look.
Where is the prayer? Where is the direction of the learned single judge?
Yes.
Does it contain any direction regarding that Oriental Insurance as well?
No, the
No,
difficulty
Your
is
Lordship.
at that material point of
Sir,
time.
please, we will hear you. Don't worry. Yes.
Lordship, Lordship.
Lordship, kindly have a look at the order so passed by the trial bench.
So if that has been repudiated, then how it can be brought within these proceedings?
Now, there's a, if your Lordship kindly turn to the order dated. The order today? No, that's Chakraborty order. Right. Yes. Lordship will find now. My Lordship will find a order dated 8th of April. Like. Prior to that.
8th April.
17th of April, Lordship will find.
Which year?
17th of April 2025. Just coming. I think this should be 30th of April. Sorry, 30th of April. The deceased wife came before this court claiming for the retirement dues for the husband concerned. So trial judge directed for the same whatever due and payable. At the stage of appeal, it had came in the scenario, what are the breakups with regard to the payments of retirement dues. If you Lordship, can you take up the order dated 30th April?
Yes, we are looking at it.
Yes, sorry.
No, that we have seen that on an earlier date.
Yes.
So now they are before us.
Now they are.
You say that is also part. Court says, all right, if you say so, we'll ask them to come. They have come. They say it is repudiated. Then how it can be considered in these proceedings?
No, how it has been repudiated.
Therefore, is it open to look into these proceedings? The repudiation of claim by a person covering the group insurance, how it can be looked into these proceedings? That is the only thing we are asking. We are not saying it is correct. We are not saying it is wrong. Whether we can enlarge this in an appeal without any prayer to this effect anywhere for the first time in the course of an appellate proceeding, look into the cause of repudiation and decide that. Or it is to be assailed in a duly constituted proceeding, challenging the repudiation in accordance with law. Thereafter comes whether it is right or wrong.
Now, one thing, Lordship, will find that as per repudiation and other things are concerned, this was not in the scenario at the very outset. Before the trial bench event, it was only a direction from the trial bench, you pay off the dues, whatever being payable to the person concerned. Only before the appeal bench, when this particular supplementary affidavit has been came forward from the LIC, it has been found whatever due and payable in which parameter is come in the zone of consideration. At that material point of time, we have came to know that what group insurance being run by the LIC has been repudiated on a
group insurance run by Oriental,
no,
subscribed by LIC,
no,
not being run by LIC. The two are very different things. It is subscribed by LIC for its employees, but run by Oriental Insurance.
LIC is paying the premium.
Correct. So they are the subscribers. They are not running the scheme.
True. But what was the cause for the same? Obviously to protect the employee.
The only thing we are asking you, whether it can be looked into in these proceedings. That was not a relief in the original writ proceeding. The repudiation is a fresh cause of action. How it can be looked into in an appellate proceedings, that also in a writ jurisdiction, the cause of repudiation, you tell us.
Takes it in that way. NPS was also not a party in the proceeding.
But whatever is admitted as, if they would have admitted, by now you would have got it, whether it was part of the relief or not. So whenever, even if it was repudiated today, let's say it has been repudiated today, then how does that improve the circumstance? Once repudiated, it has to be assailed. Therefore, no direction can, it's not an admitted due anymore. And you are in a writ jurisdiction.
Due is concerned,
Very
it's
well.
no difficulty
Very
with that.
well.
That's an admitted due.
Very
But the
well.
difficulty
Whatever you say becomes admitted due.
Lordship, kindly,
What is an admitted due?
kindly have a look
What
at
is
the
an
language.
admitted due, sir?
Kindly see it.
What is an admitted due? The payer and pay both agree.
Payer
The payer says it is repudiated, and you are saying admitted.
Now, why? Why? I'm coming to the question, why?
We are not going to look into why. This is not the proceeding.
Particular payer
This is not the proceeding.
Since you are not coming before, if you're not coming with a, since you're coming with a bald head, therefore I won't be paying you. Can it be a good ground?
Surely not. Surely not. So where is this to be looked into? We are on that. In which proceeding this is to be looked into? In a writ proceeding. The cause of repudiation.
In a total scenario,
Now you are repeating the same thing again and again. That will not help you in any way.
Well, can you have a look at their own, that is the reason I was just taking your lordship to their own supplementary affidavit, which has been given. Page 14, if you can.
Oriental has filed an affidavit.
No, they have came up with a mail. Mail. Yes.
No, where is it? Tell us. We'll look for it.
Page 9
of
from their affidavit. This is supplementary affidavit on behalf of the appellant, Rashmi Dasgupta.
Yes.
Now, what you will find on page 7. She may call for an affidavit from them, because they have not given an affidavit.
Whether we are going to go into their cause of repudiation in an LPA, that is what we are asking you. You are not making any submission on that. You are just going into the cause, whether it is just and proper. We are asking you, sir, it is an issue of jurisdiction. Please try to understand. You must be understanding what we are saying. This is a relief, this is a cause of action which has just now arisen in an intra-court appeal by virtue of a repudiation communicated. You say that ask them to pay. What is this in a writ jurisdiction?
No.
Wonderful.
Kindly have a look at the order so passed by this court initially.
We need not. This repudiation has come after that order. We need not see any order prior to that. That's hardly relevant. Please try to understand the court's query. Merely harping on the same point repeatedly will not help you. You can keep saying that this forms part of the entire claim. This is one of the retiral dues, one of the terminal dues. The payer says it is not, it is repudiated. Now, this is the circumstance which has arisen in an intra-court appeal. We don't know whether it is right or wrong. We are saying, can we go into this right now? In this new cause of action in an intra-court appeal by a third person. Now, try to understand what the court is asking you. You can keep on harping on the same thing. Nobody can stop you.
Language is so much cryptic. So would your lordship will be entertaining what is actually due and payable to the person?
We will not see. You may try in as many ways as you want to bring us to that point. But the point is the issue of jurisdiction of this court to go into this fresh cause of action arising in an intra-court appeal by virtue of a repudiation which needs to be assailed and decided in an appropriate proceeding. It cannot be done otherwise. We'll be committing an error if we do that. We can't do that. Please try to, whatever we had found was due from them, we have tried to, because seeing the circumstance, we have tried to, and whatever could come has come. The remaining, now you're in a much better footing. So, if you want to pursue, you can pursue. If you don't want, if we say something in this proceeding, therefore we are saying. Please try to understand. Every observation is not hostile.
No, that's not.
Yes.
But at least with my limited capacity, I'm trying to.
See, there are limits. You know, this is an intra-court appeal. And this repudiation, what is the date? What is the date of repudiation? On what date they have said that it has been repudiated?
সাথেই আছে, ছয়।
এটা হচ্ছে, this is 13/5/2025.
24 April আছে।
That they are maybe saying for a technical reason that it has been communicated late or whatever. We don't know. Maybe a very shabby reason. Maybe a very shabby reason. Can we look into it?
That is the reason why.
Can we look into it here?
Well, the difficulty is we came to know about these details.
That's not a difficulty. That is giving you the cause of action.
But difficulty is we came to know after the appeal has been filed.
Obviously.
We were not aware.
What is the date of the single judge order?
Yeah, Lordship will find the same.
It is of much after the single judge order.
It's much after the single.
So how can you be aware? That's precisely what we are saying.
No, not only that.
It is after
As
filing
per
of
the,
this appeal.
Breakup of the person concerned, whatever due and payable, that is also we came to know in the division bench.
We understand. See, we have got entire clear picture. You need not re-emphasize. You are a widow. You approached this court. During the proceeding, you became aware of whatever was due. Whatever we found that they were unnecessarily contesting, we asked them why they should do it. They have paid. One issue remains. You did not know this from before. But that issue now is not an admitted claim because the payer says it cannot be paid. Repudiation, you must have seen hundreds of cases, how it is to be dealt with. How it can be considered in an intra-court appeal. It's a very simple thing. We understand. And now those difficulties are quite over. You have got a substantial amount.
No,
it's not that today you are empty-handed.
We will be receiving from LIC itself.
We don't know.
We'll be receiving.
You will never receive it from LIC.
We'll be receiving from LIC.
No, sir. Group insurance will be paid by the person who is insuring.
No, they are insuring for us. It's
No.
not our, no.
They pay your subscription. The insurance cover is provided by Oriental.
Yes.
It is a very clear thing. There is no ambiguity about it.
Group insurance.
Yes, that's how it is done. We know how it works. It's not that we don't know. That's how it works. They are the pay. They give your subscription. They give your what is it called? Premium. They pay your
premium. Has been well paid. The difficulty is this: they ought to have paid back to them as far as the accident claim is concerned. This person has got a place while on duty.
You may take steps in accordance with law. We don't want to comment on that. We can't do it in an intra-court. We cannot.
These particular things, LIC have came out with an affidavit. This is
they will support you there also. They have paid the premium. They don't have to pay the amount. So there is nothing at stake for them. What is at stake is Oriental. We have impleaded them here in intra-court appeal. They have come on record with a repudiation of 13/5/25, which needs to be assailed, and that is the only due remaining.
Only due, and with regard to the interest which you were to battle on.
Which interest? On what dues?
Interest during the trial bench.
The interest. The Honorable Single Bench has pleased to direct the LIC authority to pay interest and
should be it's around 6%.
My lord, page 58 of stay application, my lord. If you will also kindly trouble to turn page 58. Last paragraph. In the aforesaid fact and circumstance, LIC is directed to divide the money into 3 parts and shall disburse. My lord, got it?
What got it, sir? The file arrangement here is really
58
impossible
of
to
the
locate anything. We don't know how it is done. So many affidavits are piled one upon the other, and you want us to look at something. There is no common pagination, there is no indexing, nothing.
Stay application, in my stay application, my lord.
Stay application.
Application for Can 1 of 2025, my lord. Can 1 of 2025. Mat number 221 of 2025. Can 1 of 2025. Filed by the LICI.
What is the date of the order?
Well, Colonel page 50, 58.
8th of January.
8th January 2025.
25.
Last, first paragraph. File. The first one.
58, Lordship will find, in the aforesaid circumstances.
May I be permitted to read, my lord?
So now all the three claimants have got it.
Yes.
As per their dues are concerned.
My lord, at first the division bench has stayed the interest portion, my lord. At first order, my lord.
So how much delay is there?
We have not on the part of, I have already submitted that as per our part, it is not our fault. It is not fault to pay the interest, my lord. Because at the time of they submitted the representation, that time the suit is pending before the London Civil Judge Junior Division Chinsura Court.
What is pending?
They have filed a suit was filed, my lord. They have, at the time of writ petition, they have suppressed the material fact that the suit is pending before the London Civil Judge Junior Division, Sirampur, my
So
lord.
you-
Chinsura, my lord.
So did you inform the writ court?
Yes, I have, my lord, kindly see. In order, my lord. My lord, if your lordship kindly order 57. My lord, 57, last paragraph, my lord. 50 order portion, my lord. In my stay application, 57. The terminal benefit of the deceased employee were to be released within 1 month from his death. The same was not done by LIC. The employee had died 4th September 2023. The amount of terminal benefit available to the legal heirs of deceased employee therefore attracts interest despite of, my lord, despite of the pending litigation between the legal heirs of this legal heirs on the simple ground that the LIC was not required to part with the money and has derived benefit therefrom. LIC is therefore required to be compensated. Despite the pending litigation, it is observed by the Honorable Single Bench, and that's order we have challenged the said order before the Honorable Division Bench, and Honorable Division Bench already stayed my interest portion, my in first order, my lord.
And for a moment, Lordship, kindly turn to page 71.
In the writ petition, they have not disclosed the civil litigation.
Yes.
There's no question of disclosure.
No
because that was not my civil suit. Lordship, kindly have a look at page
Were
71.
you party to that suit?
No,
Yes, yes, they
even,
are party.
even we are not. Lordship, kindly have a look at page 71 for
My lord, page 60, first page 60. Page 60. Kindly look, my lord, page 60. The parties of the suit.
Yes.
My lord, got it, my lord?
Yes.
Shonda Mukherjee. Shonda Mukherjee is the mother of the late mother-in-law of Shoma Mukherjee.
Yes.
Dependents Shoma Mukherjee. And my lord, LIC was the party, my lord. Kindly see page 61. Divisional of
The writ petitioner is writ petitioner is defendant number 1.
3 and 4. Stay application, in my stay application.
No, the
petitioner.
The writ petitioner is defendant number 1 in the suit.
Defendant number 1 who has not been served on the day on the order.
They have not implemented even the defendant number 1 in the writ petition. Thereafter, Honorable Single Bench has directed
Kindly have a look.
They have not intimated.
Page 72. This was the order which indicates what?
First, tell us what all has been paid. Tell us, you were saying what all has been paid. Tell us.
What has been paid?
Yes.
As of date.
Yes.
The portion LIC ought to have paid to us. In fact.
Under what heads?
Yes. Lordship will find.
Yes.
You have any detail anywhere?
Yes. Place 70, my lord. In schedule. In the title suit schedule, my lord. The LIC, kindly look. This
So from this, what all has
70,
been?
70. My lord, got it?
Yes.
The death benefit of Gautam Mukherjee due in the office of the Life Insurance Corporation of India, my lord.
Yes.
They have already filed a suit. The mother.
They are asking you what dues have been paid. What dues have been paid already? We are asking you.
As per from LIC said, we have already paid all dues.
What dues under what heads? So difficult a question. You have to say NPS or this or that, whatever it is, gratuity, PF, whatever it is.
যেদিন সেদিন লাস্ট যেটা পেমেন্ট হয়েছিল তাতে এনপিএস কে পার্টি করা হয়েছে
My lord. এটা যশোর আরেকটা কপি আছে আরেকটা
So gratuity has been paid. NPS has been paid. NPS, what is the full form of NPS?
এনপিএস কি জানো আমরা করেছি ন্যাশনাল পেমেন্ট স্কিম
Payment.
ন্যাশনাল পেনশন স্কিম
National Pension Scheme.
We have already paid one time of petition and one time of the respondent for. Therefore, it is how already paid.
Gratuity has been paid. What is GSLI? GSLI and GTIS?
GSL
GSL 1 or I?
GSLI.
What is GSLI?
gratuity leave
Group.
GSLI portion
GTIS? It's your organization, you don't even know. She would not be knowing.
GSL this is group saving linked insurance
Service linked insurance. And GTIS?
GTIS
You see, it is at serial number 4 of this communication that he has given us.
computation
Yes, this one of December 25.
Oh, group term insurance. Group term insurance. Group term insurance.
So which insurance is pending? The one at serial 2?
Well,
serial 2 insurance is pending. Come to your letter of 12/12/25, which you have given us right now.
Already paid.
All this has been paid.
On that letter, only NPS part was due, but till as per my instruction, the NPS part remaining. NPS
Now this entire thing has been
entire thing has been
herein now as per their breakup is concerned the only remains is group personal accident benefit which is 50 lakhs this is their letter
No, it's not in this list then.
but we have been served with this
What is it? Group personal?
group personal accident benefit
in annexure in my supplementary affidavit
P5
page 5 annexure P5. My lord, supplementary affidavit page 5 my lord. 1 2 3 5 6 7 8 9 paragraph 9 my lord. My lord, got it?
Paragraph.
Group E.
Paragraph.
1, 2, 3, 4, 5, 6, 7, 8. 8, my lord.
Yes.
Group personal action benefits, rupees 50 lakh, paying authority, Oriental Insurance Company Limited.
Yes, paying authority.
Thereafter, next paragraph, claim is reputed by the Oriental Insurance Company for breach of essential policy condition.
So now this 17 lakh 94 and 347 has been paid.
Yes, all.
Well, now only we are going to go into the interest issue. You give
Yes.
us the dates of the payments in a sheet. The date of payment in a sheet. We are not going to look through this mess. You are not given a compilation paper book, and we are not going to. You give us on a piece of paper. All the payments made with timeline.
My lord, we have challenging the interest portion and the my lord, kindly consider, my lord, that interest portion has been that the we have challenged the interest portion because the civil judge junior division has been pleased to pass an order of injunction.
Have you said this earlier? Have you already said this earlier?
Yes.
Then why are you repeating? We have understood your case. You are saying the single judge has not saddled any interest because of any default on our part.
Yes.
That is what you are saying. Merely because we were in possession of the money, the judge has said that you pay. This is what you are saying.
Yes.
We could not pay because the suit was pending.
Injunction was there.
Now again we are saying, before you repeat the same things again, on a paper, give us the dates on which you have made the various payments.
Yes.
On one sheet. We are not going to look through this entire thing.
I allocate 2 weeks time.
2 weeks? Why do you need? Just jot it down. Next week we'll take it up.
2 weeks time.
Yes, take down. An issue regarding the interests. No 2 p.m. Enough of 2 p.m. That 2 p.m. was because she was deprived. Now no 2 p.m.
Still deprived.
Yes.
Still deprived.
Everyone in the world is deprived.
Deprived with a deprived.
Yes.
But only last time.
In that bracket now she's
At least she's better. Can you 2 p.m.
Sorry, no 2 p.m. now.
Item number 149.
Great for your lordship.
Submit an affidavit regarding the last one.
No. We have fixed it for orders. Please don't.
Agreement, submission was concluded.
Yes, entire submission, your senior advocate has
I have not a problem, but my lord, ask them to put an affidavit regarding the last plot when they complained.
No. We have not asked them anything. What are you saying?
My lord is satisfied.
No, your senior advocate made the entire submissions.
That's the impression I had.
We'll just read the portion which is operative portion. We consider the submissions. We find substance in submission advanced on behalf of lands in question. There is no dispute that the names of the applicant writ petitioners has been entered in the RORs. The mutation applications therefore have already been allowed by the authorities. The order of the writ court therefore stands complied with. There being no direction
Item number 33.
Appearing for the petitioner, Lordship. This matter laid by Mr. Sobodhay Chatterjee is honestly in Supreme Court, Lordship. He is trying to appear the lunch period, but at this moment, matter is running before the Supreme Court, Lordship. Kindly fix a date in the next week.
as spread list after 2 weeks. Give a day.
Just after 2 weeks. Third. 23rd. 33.
Item number 36.
Regarding the dismissal of a constable who was accused of rape charge and subsequently he was acquitted, Lordship.
What is the provision?
Lordship, I have found out, Lordship, that he has been dismissed in pursuant to Regulation 5 of Rule Chapter 19 of DCRB rules, but they are separately there.
DCRB?
Sorry, Lordship. PRC guidelines, Lordship. But separately, Lordship, there is no provision in the PRC guideline for
This for the state.
They were appearing, Lordship. They have appeared all along. Lordship.
Amitabh Chaudhary. Why didn't you call? You should have called. Please bear for some 5 minutes. Where's your senior?
Code number 18, my lord, I have instruction that my lord, petitioner did not.
Item number 21.
If they give the details, my lord can dispose of it.
Where's the petitioner? Petitioner is in court.
No, my lord, petitioner is not in the court, my lord. Through phone, my lord, we have contacted to the petitioner. As per my lord instruction, my lord, we have not received any intimation or any recommendation letter.
This you have got.
No.
Lordship, this recommendation, revised recommendation, has been forwarded to the government, Lordship, and I am forwarding the handing over.
That is what we asked you, that you give them, they will see it.
Yes, I've
shown her. I've shown her.
Shown her, but she said that after when the matter is taken up, she will hand it over.
That mail is there.
You are interested in keeping it pending
No, my lord.
for all times.
My lord,
You
I
keep it
have
pending.
asked specifically, my lord, to my landlord senior.
Hey, you are both lawyers. If there is an instruction in writing, you will read it and you will say.
My lord can dispose of the matter, my lord, if
Then what is this unnecessarily?
on 65, her name is there.
You are Mrs. Ghosh, Sanchita Ghosh.
Yes, ma'am. 165, her name is.
He is OBC B category.
Yes, Lordship.
What is the serial in this list?
165, Lordship, second last page.
Page number 5 of that. Page number 5. Serial number.
And for the present, nothing survives.
Yes, yes. Kindly record it, because of that, neither it is communicated to the petitioner, neither by mail or nor they uploaded it in their website. So, the petitioner is not informed about it. So, it will be kind enough, quoting this memo, because it is handed over by my learned friend, so it will be kind enough, quoted this accordingly. She is recommended. Because it is mentioned in the heading that amendment list of candidates recommended for appointment in the post of ICDS supervisor such and such revised in view of the error detected. So it is mentioned in heading in respect of non-consideration of Srimati Sanchita Ghosh non-joining vacancy. So they admit it.
What is this error that you are referring to?
Lordship, last occasion they have shown a revised list. In that list, her name was not there. Then I have taken instruction why her name is not appearing. Then they have cancelled that earlier list, non-joining list, and this list has been revised, keeping her name in.
So in view of the non-joining, now she has come in the zone of
Yes,
consideration.
Lordship.
That is
Yes.
the basic
Yes.
thing.
Yes, Lordship.
Without any further change in her marks, she has, as it is, she has
Yes,
come in. Then nothing remains.
Yes.
The learned advocate for the commission Yes.
Lordship, Regulation 5 of Chapter 19 of PRC, Lordship. The petitioner has been terminated by this regulation, and this can be changed only with the intervention of the commissioner. He has to approach the commissioner of the police since the DCP has issued the termination notice.
Where is that provision?
Lordship, Regulation 5 of Chapter 19.
Please.
Regulation 5.
Regulation 5.
Prosecution of members.
Lordship, Regulation 5, Chapter 19. Lordship. It's disciplinary proceeding and punishments.
the relevant provision. That is the provision under which the dismissal order.
Lordship, there is dismissal order. But regarding Lordship, acquittal, there is nothing specifically mentioned in the PRC Lordship. If disciplinary proceeding goes, then what happens? That can then they can file appeal. The provision has clear regarding that. But regarding this only simpliciter dismissal in view of a conviction, nothing has been mentioned here, Lordship.
That does not answer the query.
Lordship, that is my understanding when reading this rule, Lordship, by which they have dismissed me. According to my humble submission, that for want of any specific provision, this court can intervene there, Lordship. And I have already approached the Commissioner of Police in my representation. My representation, Lordship, I have already approached the Commissioner of Police.
You are reading Regulation 5 without reading Regulation 4.
Yes, Lordship, that can go separately. But the disciplinary proceeding can go separately. But departmental proceeding was nothing, no proceeding was there, Lordship, only a punishment order in view of my conviction.
Separately, it says after acquittal.
Lordship, in my case, this is after acquittal, Lordship.
Read section Regulation 4, what it says.
Lordship, I have to approach the Commissioner of Police. What is my understanding, Lordship? This regarding after my dismissal, when I got acquitted, Lordship, I have to approach the Commissioner of Police.
But you have not done so.
Lordship, in my representation, I have made a representation to Commissioner of Police too, but there I have not specifically mentioned that I have asked for my detrimental benefits, but not specifically that I remove the punishment as well.
What is the date of acquittal?
Lordship, the date of acquittal is 21st May 2002. 2002.
When you have filed the WPSC in 25.
Lordship, this is the case where I made the representation after 17 years, Lordship, of my term.
And that also representation is not in order. So there is no representation.
Representation is to clear my detrimental benefits, Lordship.
Okay.
Then, Lordship, kindly permit me to file a fresh representation before the Commissioner of Police regarding this aspect. Because, Lordship, I have already was in service for 25 years, Lordship, before getting 25 years, Lordship. I have joined in service in 1968, 11th April 1968. And I was convicted in 4th September 1993. And I was suspended on 13th September 1993, Lordship. That is more than 25 years I was in service, Lordship.
Take a look at Take a look at
Lordship, kindly grant me liberty to file a fresh representation in proper manner and let them consider that.
What is the date of the punishment order in the inquiry by the authority?
Lordship,
what is the date of the punishment order issued by the authority?
Punishment issued by the authority, page 27, my lord, of my petition, that is 13 September 1993. The Deputy Commissioner of Police, Eastern Suburban Division, Calcutta.
Relying on conviction dated?
Relying on conviction, dated 4th September 1993. And I was acquitted on.
In which case? Case number?
Lordship, case number is Fulbagan Police Station, case number 108, dated 23/9/1992, under section 366, 376, 114, and 354 of IPC.
Acquittal is dated.
Acquittal dated 21st May 2002. Page 58 of and 59 of my petition.
Why you were sleeping for 17 years?
Lordship, that's the problem. The petitioner was of the view that he will get nothing and he can't join. And he was not that, semi-literate person, Lordship. He went to his native place. And later on, maybe some people has advised him, Lordship, and he came.
And there is no, you could not find any provision requiring him to inform the authority regarding the acquittal.
Lordship, what is there, that is there. I cannot improve my
No,
case.
there is nothing there in the rule. We are asking.
Lordship, he didn't inform anything, Lordship.
No, there is nothing in the rule requiring such intimation being given.
Should be, in my opinion, he should have done.
No, but it is not there in the rule. We don't find anything. In fact, the government will be knowing about his acquittal because they are party to the proceeding.
They were aware, Lordship. And during pendency of this case, they have cleared the gratuity. And Provident Fund is a separate thing, Provident Fund also. The state has cleared the gratuity during the pendency of the application before the administrative tribunal. Now I came on.
You are working as a constable.
I was working as a constable. And I was in service for more than 25 years.
The